a judge who is presently sitting out there in the court.
Yes.
So you need to mention it before him, irrespective of what bench I am taking.
Yes, Lord. Provision says like that.
Then why are you mentioning it before me?
But Lordship, actually I am a respondent. I am not petitioner. Because Lordship thinks that he is taking up the criminal matters only.
So what? He has to review it. I can't review it. So you have to mention it.
Yes, Lord.
Wait, with the Lordship.
Hmm.
Lordship, I beg to mention one CRP, Lordship. For listing in admission column, notice was issued, stay was granted. I am for the sole respondent.
CRP what?
CRP, Lordship, the petitioner challenged the Order 7, Rule 11 petition was given, Lordship. That was rejected by the learned trial court. My plaint was not rejected. Against that, it's CRP, Lordship.
And they just stay.
Lordship.
We will have it on 27.
Offline.
I for release the order. Can it be on Friday, Lord?
Friday?
This Friday.
No. Next
Monday,
week.
Lord.
Monday you can come to the court. We can have it on Monday, next Monday. First of April.
Yes. I pray for listing of an MSc appeal. There's the outside court settlement. So can it be taken up on 27th? Much obliged for order.
You file an IA.
I am.
You filed an IA? No.
No.
And how do I know that there is an out of court settlement?
No, there is an agreement by both parties that will be.
How? You will just give it to me, I can take it? No.
Lord.
There has to be a joint affidavit.
Yes.
File that.
Right.
Then only we can.
Right.
File that, then mention.
Right.
Not now.
Okay.
Yes.
Wait, please, sir. So I beg to make that an IA member. The appeal is listed on 22nd. Your Lordship gave us the liberty to file an IA. The FAO. So I beg to make that for listing of the IA along with the appeal.
You file the IA or not?
No, IA we have filed.
So tell the registry that you have filed the IA. The matter is already fixed. Why do I? You don't mention a matter of a IA.
Right.
Take it up with the registry.
My petitioner. Your Honor, I am mentioning for withdrawal, Your Honor. MSc appeal number 521/18, 241/17, 461/17.
Yes.
For withdrawal listing on 22/3/24.
Withdrawal.
Yes, Your Honor.
Yes.
I beg to mention CRP number 20 of the 23 hearing column. CRP number 20 of the 23. This was a pending Lordship. It was last listed on 19th of January. 19th of December 2023. It is fixed for hearing.
It's already in the hearing.
Yes, Lord.
Take it up with the registry.
We had already began part of it.
Then file an IA. Can't help you the other way.
Another pair Lordship. IA Lordship in FA Lordship. It was maybe listed for orders Lordship. This was issued.
First.
With due permission, Lordship would like to mention item 25 of today's report. It has been listed after service of notice for the first time today, Lordship. I am appearing on behalf of the respondent, Lordship. I seek 2 weeks time to file the written objection.
Item?
Item 25.
That is for what?
Lordship, basically it was a MSc, it was a matrimonial appeal, and in filing that appeal, they have filed one IA. So that IA has been dismissed for default. Against that, they have filed one miss case for restoration of the IA, Lordship. So I am appearing on behalf of the respondent. I seek 2 weeks time to file the written objection to that miss case, Lordship.
How much delay?
But more than 1 year.
After more than 1 year, they have filed that.
They have filed a restoration application, Lordship.
The request of the respondent, the matter stands adjourned to be listed after 3 weeks. In the meantime, the reply be filed by the Yes.
My lord, I am saying for listing of CRP IO. In the trial court, my lord, next date is fixed on 30th March. My lord. It is, I want a interim order, my lord. Before
30 March.
30th March.
Saturday. Hello, we'll have it on 27.
I'd like to mention for listing for CRT IO method to come in the office call on 3rd of April.
3rd of April.
3rd of April.
Take it up with the registry. Why do you want it on 3rd of April?
So
You can't get it listed? CRPIO.
it was last listed on 27/9/2023.
Tell them, list it. Why should you mention it is matter? The registry is not helping you out.
It would come in the orders. Right?
Why? What order do you want?
So services, it is still up for the second time.
What order do you want in that matter?
My application for amendment was partly allowed, and my amendment for to the relief portion was not allowed. So today I have filed this CRT.
Now, what do you want? Not in the final relief of IO. Why do you want it in orders?
I have issued notice. So notice
Has been served. So don't you think that it is a case for coming in admission?
Yes.
Service complete.
only for the main defective, for the respondent, not for the part.
You have made the performer, then you have to. It will come only after the service is over. But otherwise, you have to go for striking out. Okay, third. Yes, next.
May please, your lordship, with the consent of the other side, I'd like to mention item number 37.
You are
I'm for the petitioner. Lordship, the respondent side has filed an IA and we need a week's time to file the reply.
which one? 37.
37. Order.
What is this IA for? IA for what?
Lordship, I have received it yesterday. I have not perused it.
Oh, peruse it, then mention. Don't make this type of mention without knowing.
We-
We'll take it up. You want, we can take it up as the first item.
if I-
We'll have it when the matter is.
Like-
And it's a student of 18 years old.
Huh?
Here in this case, man, petitioner is a student. He want to pass to her studies, further studies. So,
What is the next date?
and next there is 34, man.
30?
2024.
Okay, we'll issue notice.
Madam.
So make it served. Then we'll grant stay.
Man. Before 34, man. Next date maybe before
33.
34.
34.
30th April, man.
Issue notice making it returnable by, where is the respondent? Gorbeta.
More better, man.
Issue notice making it returnable by 22nd of April 2024. The petitioner is directed to take steps by way of registered as well as usual. Further to that, the petitioner is also given the liberty to take steps by way of dusty, routed through the registry of this court and file an affidavit of service on or before the next day. This court, taking into account that the next date before the trial court is on 30/4/2024, is not inclined to grant an interim in any interim order. And the interim order, if any, would be considered on the appearance of the respondents.
Highly ordered.
Lordship, this is for transfer of metropolitan property. It is pending in the court of the learned principal, the Supreme Court, not very year.
Yes, what do you do?
It's now she is presently posted in the CISF unit when she is the constable of medical. And in the same unit, your lordship, the respondent also is also presently. Actually, they are living in Durhat. They are living in Durhat, the CISF unit that is in Durhat, Sinabad. So that jurisdiction of the district and session judge of that Durhat, actually they come. But in spite of that, the husband he went.
But both of them are now staying in Jorhat.
Yes, ma'am. They are staying there.
But tomorrow again, what happens? You want it to where?
Now they are in the,
Where do you want it now?
in Durhat, your lordship, because it will be convenient for both the parties.
When is the next date?
Next date on 30th April, your lordship.
30th of April.
Yes, my
Yeah, আগৰটো নিচিনা order দি দিম. We'll have it on 24th.
24th of
22-4.
20.
Take steps by way of the stay also, and so that when both the parties appear, we will do it.
Yes.
This court is not granting us stay now because the matter is fixed on 34.
30th.
Yeah, case number 2 है Twitter case number. This is an application for transfer of the Twitter. Yes, what is this?
Yes, please, your lordship.
You are challenging which order?
Your Honor, order dated 13/12/23,
Where is it?
of learned civil judge number 2 class.
Where? Where is the page?
Where is the, Your Honor? Annexer number? Annexer 5, your
Page.
page number.
Hello,
50,
madam, you prepare it properly.
58, Your Honor, 58,
50.
58.
Yeah. Yes, what is that? Huh? What order are you challenging?
Your Honor, ex parte vacate order.
What? 58? Are you aware? 58 is an order passed by this court.
No, Your Honor.
What order are you
Just a minute,
challenging?
Your Honor.
Next.
14 to 34, Your Honor. Sorry. 14 to 34,
Where is that order?
Your Honor.
Where is the order you are
Your Honor,
impugning?
page number 14.
14.
Fine.
Then
Yeah.
tell me that. 14 is a plaint. Are we in CRP number 107 of
Yes,
2024?
Your Honor. Yes.
14 is a plaint. I think, madam, you need to prepare
Page
your
number
matter.
35, Your Honor.
No, you prepare your matter properly. Please the matter on Friday. By that time, it is hoped and expected that the learned counsel would be prepared with the matter. By stay. Prepare your matter properly. Don't come up before this court without knowing. You're mentioning this page, that page, whatever it may be. Next.
Four.
None appears on behalf of the petitioner on call. Accordingly, for the ends of justice, matter stands adjourned to be listed on up to 2 weeks.
Yeah, it is, Your Lord.
Yes, contempt for what?
Yes, sir, contempt matter. That was the judgment passed by the Honorable Court.
Huh?
Passed by the Honorable Court. on
Which order? 5-6.
2023.
What is the order?
And the order was that the tenant shall attend the suit premises within 6 months and shall also undertake to visit. And thereafter also there was a direction of the Honorable Court that this maternity judgment that the tenant shall remain in possession of the suit premises custodian, and during that period they shall not create any act or act by which the right of the plaintiff is affected. Your lordship may kindly come to the operative part of the judgment passed by this Honorable Court at page number 34. At page number 34, my lord. That is the operative part of this Matrimonial Honorable Court. I am reading paragraph 25, 24. It is clarified that during this period of 6 months, the defendant shall continue to make payment of the amount of 280.
No. Tell me. Did they give an undertaking?
They have not given.
So obviously, there a failure to submit the undertaking within the period, the plaintiff shall be entitled to initiate execution proceedings for evicting them.
That was filed by.
So,
Filed by.
Hmm.
But there was a direction, my lord, by this Honorable Court I am reading that part at page 25.
Page?
Sorry, page 34, paragraph 25.
That
It is also clarified that during this period, the defendant shall remain in possession of the suit premises as the custodian of the plaintiff, and shall not do any act or act which will affect the right of the plaintiff over the suit premises. That was a clear direction from this court. But before expiry of the 6 months, he have created a tenancy. It's one of the
he has?
created a new tenancy. Created a new tenancy on 13/11/2023. It effect from 1/11/2003 with one of the legal years without our knowledge. That was the statement made by one this my lord Ram Kishan Vaisri, who was not the judgment debtor, and that will appear, my lord, from page number 38. That order was passed by the executing court on 19/2/2024, and there, my lord, this petition was filed by this on Ram Kumar Vaisri, my lord.
Oh, writ has been already issued. Writ has been already issued.
But that was stayed, my lord.
Huh?
That was stayed.
Why?
Because they approached the district judge. For that, I have enclosed this order also.
Where is that order?
That order is, my lord, at page number this 41, page number 41. He approached the district judge by filing a transfer petition, or in the transfer petition, the impinned
Where is this? Have you challenged this order?
my lord, I have not challenged. I have not challenged because I did not get. In the meantime, my lord, I have filed because today is the date fixed before the district. They did not supply all the documents to that. Only this mortality order we have received. So that
Let us have it after 2 weeks. We'll fix a date. Let us have it. I'm not issuing notice now. Let us have it after 2 weeks. In the meantime, if the district judge does anything out there, you challenge it.
Interesting also, my lord. Tomorrow my client informed me that today my client informed me over telephone that they have also filed a civil petition before this honorable High Court challenging that order which has been stayed by the district judge. And that order, filing this revision petition, it is the honorable court, my lord, that is the order. Again, state the proceeding of this title sentence, my lord, on 1/3/2024. So we only received the notice, proper document. So this may also kindly report. That is a clear violation of direction given by this honorable. They did not care, my lord.
Okay, we do one thing. List the matter on 27/8/2024, 27/4 to 27/3/2020, 27/3/2024, along with CRP IO 92/2020. Don't worry, I'll take care of it.
Yes.
I'll vacate this, that, and then direct the trial court to immediately execute it.
It did not care, my lord. Willfully and unknowingly, everything.
No, let this matter come up out there. I'll take. Don't worry. Yes, what is this?
Due to some problems, we are out of this time.
Huh? You're asking for against what? Temporary injunction. You gotta stay. Vacate the stay. Then you no stay. Nothing.
But, they have challenged the order that your lordship will find at page 48.
Page
48.
48 by whom?
By the lord Civil Justice Rupi. Order dated 7/4/2022. That has been challenged, by which the lord injunction petition was rejected.
And he has filed under what provision?
order 39-1.
Huh?
Order 39, rule 1 and 2.
No, here.
Here, my lord, it is under 227.
This is an application under Article 227 of the Constitution challenging the order dated 7/4/2022 passed in Mizze case number 10/2021 arising out of title suit number 5/2022. So, the impugned order which have been challenged in the instant proceedings is an order passed under Order 39 Rule 1 passed in a proceedings under Order 39 Rule 1 and 2 of the code. Under such circumstances, an appeal lies under Order 43 Rule 1R, read with Section 104 of the code. In that view of the matter, in view of the well-settled principles of law, the instant jurisdiction under Article 227 of the Constitution of India cannot be exercised. Consequently, the instant petition stands dismissed.
Applies.
7.
Yes, who is appearing? None has appeared on behalf of the petitioner on call. Full stop. Taking into account the above, this court adjourns the matter to be listed after behubication. Interim orders which have been passed earlier stands vacated. Yes, what is it?
45, with the impugned order enacted in page 36.
Where's the other side? Name shown? Okay, no problem.
File that was IA for stay vacant.
You are challenging which order?
For that. Page 36. Before that, may I take your lordship to the judgment?
FN को बोलो कोई भी. Yes, what are you asking?
My case, lordship, that as per judgment and decree, lordship, that if it is lordship short, then that be adjusted towards the northeast side of the Schedule 1-4, saving my house. There's a clear indication in the judgment. So I have filed one petition annexed to a petition under section 47, read with 1. It says, lordship, there is a deficiency of 13/10 in execution. So my prayer was that if the decree is executed as per the case map, the defendant judgment letter shall lose their only heart and home and shall sustain irreparable losses and counted by money value, it would be more or less to the tune of rupees 5 lakhs. They have sufficient land towards north side of the Scheduled 1 land on the Scheduled number 12 to satisfy the decree. That was rejected. For that, your lordship can see the judgment page 60.
Determine in satisfaction only on the northern side of the Yemen and place where the defendant has got sufficient land. What do you want?
But from saving my land from both sides, the vacant land is there. That may be taken. 30. That
Then
is-
why was it rejected?
That was rejected, the lordship said there was no such lordship direction from the.
Did you construct during the pendency of the suit?
As for that only, I am saying before the lordship to see page 16.
Huh?
Page
No,
16.
here it says categorically.
No, lordship.
Peruse
that
the
is-
case
that is
record,
wrong,
the
lordship.
decree in Iman, and since then, for the last 18 years, the decree holder is waiting to get the fruits. It is further seen that now the judgment debtor does not challenge the survey report, but praise an unequitable ground that the decree may be executed, saving his cowshed and other structures which he had constructed either during the pendency of the suit or during the presidency. This is, how can it be? This is
No,
your
no,
petition.
That is clearly wrong, lordship.
No, here, what are you saying in your application? Kindly see.
The judgment itself says that lordship, our house.
There is no convincing evidence of the alleged dispossession of Iman. The survey has been conducted so and so and so and so. The survey report indicates that here there is a 5% under the possession of things thus because there is a deficiency of the defective. Now, show me the decree.
Page 24, while discussing issue number 234.
No, what is the decree? Suit is
Decree-
decreed in
yes,
contest.
sir,
Plaintiff
decree
has a
page
right,
20.
title, and interest in respect to the 12 kathas, two
Two
chatak of
chatak, yeah.
land within the first schedule, subject to satisfy that the decree by way of survey at the time of execution of the and the recovery of the schedule 1 for land shall only depend up if the decree is not satisfied with the land in possession of the plaintiff in both sides of each and cost. There is not mentioned, there is nothing.
Lordship, that is the clear direction, lordship. Decree recovery of schedule 1 for.
There is no direction.
No, lordship, recovery of schedule 1 for land shall only depend upon.
If the decree
is
is not satisfied with the land in possession of the plaintiff in both sides.
So,
Then-
lordship, in the middle, my house is there, lordship.
But you have stated out there, it is seen that now the judgment debtor does not challenge the survey report, but prays on an equitable ground that the decree may be executed, saving his cowshed and heir during, considering that the structures were made during the pendency of year.
That is wrong. For
Where is
that-
your statement that you constructed the cowshed prior to the suit being filed?
Judgment itself says, lordship.
Huh?
Issue number 34, while discussion, lordship.
Where?
24, lordship.
Issue number?
234, lordship. Page 24, original judgment. I have read. Regarding delivery of possession, page 25, first paragraph. Regarding delivery of
The
possession of
defendant
the
contains the delivery of possession of the suit land. Possession of the suit land. Where is it mentioned? There's nothing.
lordship, the further reveals from the materials of record.
Paragraph, page.
That is lordship, page 25, regarding delivery of possession of the suit of land, lordship.
Where is it mentioned that there were cowsheds and houses?
It further reveals from the materials of record that there were two kacha houses were already in existence.
Hmm.
PW2 during his process stated that one of the house was east-west, which was shifted to north-south, attracting 7-8 cubic net of the plaintiff. On the other hand, PW5 during his process stated that the defendants have been residing over the suit land since 1520. That is my only residence. Yes, such other PWs also did not give the exact description of the land disposed by the defendant. Besides, from exhibit 4 series, it appears that defendants paid house taxes since 1992 on different occasions, apart from during local inspection. it is seen that there is an old facet Chautala house on the eastern portion of the Schedule 1 call land and another deep looking house on the western portion of the Schedule 1 call land, which also appears to be not recently made. Toward adjacent it, there is a ground pin level RCC structure. It is also worth mentioning that there are varieties of tents and bamboo ground groups on the western and eastern portion of the Schedule 1 call land, whereas the Schedule 1 call land is admittedly wheat land, and there is no sign of having.
Where is the plaint?
Plaint I have not annexed on this
So?
document, I have it.
On that
It is
ground
admitted-
itself, we don't know. No, we are not going to entertain this type of thing. This
Plain
was,
ownership, they
no.
have annexed in
There is
their.
a stay?
Yes, but
No, we vacate the stay.
not
This is not the case. You have categorically stated out there that these are constructed during your pendency.
about
You
it.
cannot come
The
up out
judgment
here and
itself
say.
says that lordship already there were houses, but
No.
not that only.
The decree does not say anything not to demolish the house or anything. I would not interfere with the order, but only say to the trial court, executing court to go ahead in terms with the decree. No, nothing more.
The decree says from.
You
both
can aware
east
that
and
the
side
decree does not say that not to disturb you as regards the houses.
Yes, but only to save my house.
No, absolutely no.
Lordship one co it
Therefore,
clearly says.
This is an application under Article 227 of the Constitution challenging the order dated 8/11/2023 passed in Misday case number 187 oblique 2023 arising out of title execution case number 10 oblique 2016 by the Court of the Civil Judge Senior Division, Hailakandi. From a perusal of the materials on record, it reveals that the decree holder had filed a suit before the court of the Civil Judge Senior Division, Hailakandi, which was registered and numbered as title suit number 32/04. The said suit was decreed in favor of the plaintiffs, holding inter alia that the plaintiffs are entitled to the declaration that they are the owners of 12 katha 2 chataks of land within the first schedule. Further to that, it was also decreed that the said declaration would be subject to the satisfaction the said declaration and it was further decreed that there would be a survey carried out at the time of execution of the decree, and the recovery of Schedule 1 bracket 4 land shall only depend upon if the decree is not satisfied with the land in possession of the plaintiffs in both sides bracket east and west of the Schedule 1 core land. Pursuant to the said decree being passed, judgment and decree being passed on 23/6/2005, 15 or 5, 5. Pursuant to the said judgment and decree passed by the learned trial court on 23/6/2005, the decree holder filed an execution case before the executing court, that is the Court of the Civil Judge Senior Division, Hailakandi, which was registered and numbered as title execution case number 10/2016. In the said proceedings, an application was filed by the judgment debtor under section 47, read with section 151. stating inter alia that the survey had been conducted by the ASO Lala, and in the survey report it was indicated that 3 strips of land in the trace map within DCFE, there were found 5 kathas, and within HGHI was found 3 kathas, 5 chataks under the possession of the plaintiff. It was also stated that within EFGH, 3 kathas of land were found wherein there is a CIC wooden frame cowshed and 1 dwelling house, half wall, CIC part of house, and in the middle courtyard having some betel nut trees. Further to that, it was also stated in respect to the said survey report that within DCJI, there is 5 kathas under the possession of the plaintiff, plus 3 kathas disputed, plus 3 kathas, 5 chataks under the possession of the plaintiff. Under such circumstances, the deficiency is only 13 chataks. It was also stated in the said application that if the decree is executed as per the trace map, the defendant shall lose their only heart and home and shall sustain irreparable loss, which reasonably assessed would be at rupees 5 lakhs. Further to that, it was also mentioned that sufficient land towards the north side of the suit Schedule 1 land on the same suit, the number 131, to satisfy the decree. The learned executing court by the order dated 8/11/2023 passed the impugned order, thereby rejecting the application filed by the petitioner oblique the judgment debtor. This court have duly taken note of that the learned executing court had taken into account the contents of the said application filed under section 47, and also had observed that the judgment debtor, that is the petitioner, did not challenge the survey report, but prayed on equitable ground that the decree may be executed saving his cowshed and other structures which he had constructed either during the pendency of the suit or during the pendency of the present execution proceedings. The learned trial court, executing court, further taking into account that for the last 18 years, the entitlement of the decree holder having not been able to, I had also taken note of that for the last 18 years, the decree holder have not been able to get the fruits of the decree. And the objection to the executability of the decree as made was not maintainable, for which the said application under section 47 was dismissed. Being aggrieved, the instant proceedings have been filed. This court, having taken note of the above facts, and more particularly Upon perusal of the judgment and decree dated 23/6/2004, 5, is of the opinion that the learned trial court, while passing the said judgment and decree, had duly declared the right of the defendant respondents herein, declared the right of the decree holders oblique the respondents herein in respect to 12 katha, 2 chataks of land within the first schedule. In the said decree, it was further mentioned that there would be a survey report at the time of execution of the decree, and the recovery of the Schedule 1 core land shall only depend upon if the decree is not satisfied within the land in possession of the plaintiffs in both sides bracket east dash west of Schedule 1 bracket core land. Full stop. This judgment and decree dated 23/6/2024, the 23/6/2005 have not been assailed. Full stop.
Up to 2016 arrest was.
Huh?
2016 arrest was.
What was assailed, but was assailed, and in the year 2016, the second appeal, which was pending before this court, was dismissed.
No.
Therefore, said the said judgment and decree dated 23/6/2005 have already attained finality. Full stop.
Allowed, my lord. Appeal was allowed. RSA was allowed. Taking our I am the respondent here. I was appellant here.
That is not mentioned anywhere, na? Have attained the judgment and decree dated 23/6/2015.
Well, the respondent, right?
5 have attained finality with lecture. RSS, they have not mentioned. Good. Under such circumstances, the executing court has to execute the decree in terms with the decree so passed, and it being well, and more so, it being well settled that the executing court cannot go behind the decree. Full stop. Under such circumstances, in that view of the matter, this court, upon perusal of the impugned order dated 8/11/2023, is of the opinion that the learned executing court had not erred in law, or there has been any jurisdictional error committed in rejecting the application under section 47 of the code. Consequently, the instant petition stands dismissed. This court have also taken note of whether there was that by an order dated 12/1/2024, this court had stayed the further proceedings of the execution case number 10/2016. The said stay order stands vacated, and as the parties are represented before this court, the parties are directed to appear before the learned executing court on 22/4/2024 for further proceedings of the execution.
My name may kindly show me.
You give your name in a slip.
Fine.
Yes, properly, in bold letters.
My lord, appeal against my lord, the judgment and decree matter dissolution of marriage. The appeal has been prepared by the wife. At page 17, the
There is no IA?
No I. No I.
What has happened? Decree, your prayer for dissolution is hereby allowed, since the petitioner is the biological father of the son who is presently in custody of the wife, may visit him as per the conditions mutually agreed. The marriage between the parties is dissolved and the decree for divorce is started. Now, what do you want?
My lord, record equal for my lord.
No. If you are not asking for stay,
My lord, I will file my lord with
file your stay. Otherwise, why should we?
Yes.
One day and then you don't file a suit. and tomorrow the person gets married out there, then again we are going to do anything. There has to be a stay. Mr. S. Sohan, the learned counsel appearing on behalf of the appellant submits that's for an accommodation of 2 weeks for filing an appropriate application seeking stay of the judgment and decree passed by the learned trial court. To list the matter again immediately after the Bihu issues.
This appeal filed, my lord, these are analogous matter, my lord, for enhancement of the award. Only 45,000 given, my lord.
What is the
Pass,
ground?
Lordship.
What is the ground?
Yes, my lord. But nearest persons, my lord, and similar judgment, my lord.
Huh?
Nearest person, my lord, Dolil was exhibited there, and similar judgment has been already, my lord, here. And in view of the one judgment has been mentioned here in the judgment also, and similar matter has been already, my lord, admitted. My lord. Out of
What?
the same series, my lord. Then-
Don't worry.
Yes.
I will try to dismiss all if I have to. Then you can very well take that help and show it in the coordinate bench that similar matter has been dismissed.
And recently, my lord, one judgment passed by the Honorable Apex Court, my lord, there it is enhanced up to 3 lakhs, my lord.
Yeah.
I have annexed here. Only 45,000 given. Subsequently, court below, my lord, given 90,000. And it is enhancement for 2 lakh 50,000 only.
What evidence did you give?
My lord, the exhibited, my lord, the my lord, Mondal also was called, my lord.
It was increased from 45 to 90,000.
Yes, only 45 to 90.
How much
Per
did you
visa.
ask for?
2 lakhs 50,000, my lord.
Okay. Where? Where is the land?
Dudna area, my lord. Dudna area. Dudna area.
Dudno area.
It is a remote area.
Remote area. And what is the proof you gave?
Lordship.
What is the proof you gave? Evidence is what?
Evidence, my lord, some exhibits were here, my lord, Dolil of the nearest area, my lord. That was
What did you give?
Dolil, my lord. Sell deed, my lord.
Sale deed.
Sell deed.
And those sale deeds have not been considered.
Not considered, my lord.
Where is that? 2.5 liters and in the period is entitled to 2.5.
Yes, 20.
He did not submit any regard to total land. And your land was what?
Pattaland. Pattaland.
Miadi.
Yes, my lord. Agricultural land. And one judgment, it was received, my lord, for my enhancement, my lord, 2019 for 87.
Chalo. You should notice. Which are the cases?
10, 11, and 12, my lord.
10, 11, 12. You are appearing for whom?
I am for FI number 3, Lord.
State of Assam.
Yes, sir.
And where is the DC?
What?
Mister? Where is the DC?
Sorry, 2N.
No, railway.
Respond number 3 is the DC.
DC,
He is
yes.
the collector.
Collector, I am appearing for FI number
Okay.
1.
Why the appeal is valued at 64,000?
600, my lord.
How much land was your acquired?
1 kata 5 lesser.
1 kata 5 lesser.
Yes, 90,000 per biga. It was considered by the land.
So on that basis you have
On
done. Oh, then it's rightly done. If you appeal, you are paying the court fee on that basis. Very well.
But we are the land loser. We are the land loser, my lord.
So what?
That-
No, no.
Generally, in
You are admitting that 90,000 should be per biga.
that enhancement against that difference, my lord, that has not been calculated. But
No, no. If you are, it has to be on the basis of the claim.
250,000 was the claim.
So what was your amount you claimed?
250,000 per biga.
You had only 1 kata 5 lesser.
1 kata 5 lesser. Only 28,000 given. 28,000 rupees given. 1 kata 5 lesser by the government. Subsequently, it has enhanced. Enhanced up to 1,12,000.
And government, yes, are you not paying the amount? There has been an enhancement. Because if you see this court, you are not on appeal. Remember that. Earlier it was 45,000.
Yes.
It has been increased to 90,000. Now he is not in appeal. You are not in appeal. He is in appeal. So there has been an increase. Are you not paying that? If you don't pay that, interest will get an accumulating 9% and 15%. Chalo. Appeal admitted, call for the records. As the respondent numbers 1, 2, and 3 are duly admitted, represented, extra copies of the appeal be served upon them. Is duly as the respondent number 1 and 2 is represented by Mr. C.K.S. Borua. C.K.S. and Ms. Coenso, Ms. D. Bourbon appears for the respondent number 3. Extra copies of the memo of appeal be served upon them during the course of the day. List the registry shall call for the records and list the matter for hearing immediately upon receipt of the reports. This is an appeal directed against. This is 54.
Yes, 54.
54 appeal.
54, my lord.
Under
The
land
date of
Restriction
judgment is
Act
the same date.
1890.
21/12/9.
What is this? Landlord tenant.
Yes, my lord, landlord.
Then
My lord, may I pray that this be taken up after the fact? To take a dead fifth upon. Otherwise, it's a landlord tenant matter. It has been remanded by the
appeal
appellate judge.
succeeds. Case is remanded back to the trial court for fresh trial. How is this possible?
My lord,
Against the remand, what will like? Against the remand, what will like?
my lord, appeal should have technically.
Huh?
Appeal, my lord. However, the act bars the appeal. Therefore, we have preferred.
Why?
The tenancy
You under section 8.
8. Therefore, we have preferred a CRP.
Landlord tenant. You are the tenant.
I'm the landlord, my lord. We have sought for recovery of
You
tenant.
want an adjournment.
Not an adjournment, my lord. Just pass over for the time being.
Why?
My lord, Mr. Dick, My lord, Mr. Dekka had a dentist appointment. He is on his way. He'll just take 5 minutes.
I'm for the respondent.
Yes.
I also seek for a passover.
Why?
P Decca is on legs in another company.
Well, to pay money not there. Why should I be bothered? Leaves the matter of the behuvication at the on such date as the councils may apprise the registry to do so.
My lord, there is an interim order.
Interim order. Interim order for what? For not to proceed. You are the tenant?
He is the tenant.
Yeah. He's the landlord or tenant.
He is the tenant, my lord, and the landlord.
So the interim order we make it absolute. He doesn't mind. Till the disposal, it is not goes there. You know, man.
No, my lord, I'm sorry, I did it wrong.
Huh?
I'm sorry, my lord, the interim order is not approved.
Interim order is there, but not there.
Not there, my lord. I'm sorry, I made it wrong. Otherwise, my lord,
To take a- Why it is not there? Interim order is there on the first day when I took it up. Accordingly, the impugn order dated so and so passed in title appeal is stayed till the returnable date. And earlier on 28/11/2022, interim order passed earlier shall continue till the returnable date. Then why you are saying that no interim order is there? You better admit this. Then you can take your time, both of you. Hello. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, as well as so-and-so appearing on behalf of the respondent. Both the counsels have sought for an accommodation. Taking into account the above, this court fixes the matter on
next
6th of May 2024. Interim order passed earlier will continue till then.
Deep level.
petitioner herein, the plaintiff, my lord, who had filed the title suit, my lord, praying for
First and foremost, where is the impugn order?
my lord, impugn order, my lord. Page number 76.
Page
76.
73.
76, my lord. 24 to 22. In which the order of the munci.
You are saying about 63. What is the impugn order?
My lord, 76.
How you
The appellate court order.
76.
The munci had, my lord, passed an order for maintaining the not to change the nature and feature of the suit. It was the injunction. Page number 60 is the, my lord, munci order.
Hello. Who is the plaintiff?
We are,
What did you ask for?
my lord, page number 18 is our prayer.
Where is your plaint?
Page number 18 is the prayer. My lord. Okay,
Plaint is where?
plain. Page number 13, plain, my lord, and 18 is the prayer.
Plaint. Page
Page, my lord, 1-3 is the plain,
1-3.
and the relief, my lord, 1-3.
declaring that the plaintiff are the legitimate possessors of the scheduled pair and they have been illegally dispossessed on demand by the defendant. Plaintiff be restored. So you are not in possession.
Not admitted.
What is your injunction paid for?
My lord, injunction, my lord.
Where is your injunction? Injunction application. Injunction. Under enforcer RERA may be pleased to guard an ad interim injunction and RERA restraining them not to change the nature and feature of the suit land.
It is allowed.
Now thereafter on
It's allowed.
the trial court,
Allowed. My lord, page
trial
number
court order
63, my lord. 63.
a long order they have written.
In operative 74, my lord. 74, 73.
Then what does the appellate court say?
Appellate court, my lord, page number 76, my lord.
Yes, Mr. Ghosh.
My lord, kindly see page 82, last paragraph. 82 and
Yes.
83. The plaintiff has petitioner filed the suit for declaration so and so. Admittedly, the petitioner plaintiff are in possession of the suit land. It is
Are not in possession.
wrong fine. Wrong fine. But then the appellant opposite party claimed that they are claimed that since they are purchased, they
Who is the appellant?
are the appellant. No, my lord.
No, you are the appellant.
Yeah, in trial, yes. Before the
First appellate court, you are the
first
appellant.
I am the appellant.
Then
Yes.
that is what has been
Yes,
mentioned.
recovery of possession, and we are possessing the suit land, and there is a mention that this suit land on the basis of purchase deed from by us. It is not that we have been dispossessed them. Since long we are possessing on the basis of purchase.
Hmm.
Now
And-
they are filed only section 6 of specific relief act case.
Is it section 6?
Yes.
When was this suit filed?
With 2021.
When? January.
Yes, sir. Yes.
They say their basic case is that they were in possession till from 10/12/2020 and on 10/12/2020 you dispossessed. Rightly or wrongly? It's a section 6 proceeding. He doesn't have to show his title. So if you have dispossessed and he has filed a suit on 4/1/2020, 21,
21. 21.
20,
Well, it-
you have been dispossessed when? You are dispossessed on 10/12/2020.
20. It is
When
a
did you file the suit?
21, my lord. It's wrongly typed.
Then?
21. Suit no, dispossessed. Suit is registered dispossessed on January 21. It was on December 20, my lord. Suit is January 21. And
So if it is filed on January, it is within limitation.
but what happened during the trial in course of trial,
they were not late evidence. It was proceeded then ex parte. Then application has been filed for vacation of ex parte. They are lingering the suit till date. They have not adduced any evidence in the case. And this honorable court, while issuing notice, status quo order has been passed.
You want that status quo?
That
With that status quo only he wants, isn't
status quo, I don't have any
which
objection.
means that you cannot change the nature and character. Well,
But only prayer is that the suit may be expedited, my lord, be filed by them. Because otherwise, by taking this status quo order, they are lingering the suit. In the process, I am suffering. So let the suit be decided as expeditiously. Because they are taking time. We are not taking any time.
and as suit for specific performance, section 6 has to be disposed of
Within 6 months.
That may be my thought, that may be my lord directed to that court.
This is a application under section article 227 of the Constitution challenging the order dated 24/2/2022 passed in Miss Appeal number 6 of the 2021, whereby the learned first appellate court, that is the court of the civil judge Hailakandi, had set aside the order of injunction dated 28/10/2021 passed by the learned trial court, that is the court of the municipal number 2, Hailakandi. From the materials on record, it reveals that, that it is the case of the petitioners herein who were the plaintiff, that they were in possession of various plots of land as described in the schedule to the plaint. On 10/12/2020, the defendants forcefully dispossessed the plaintiff, and therefore on 4/1/2021, the suit was filed under section 6 of the Specific Relief Act 1963 for recovery of possession. In the said act suit, which was registered and numbered as title suit number 6 of the 2021, an injunction application was filed, taking injunction to a limited extent that the defendant should not change the nature and character of the suit land. Change the nature and feature of the suit land till the disposal of the suit. The said application seeking injunction was registered and numbered as Mizze case number 5/2021. The learned trial court, after hearing the other side and also taking into account the written objection, granted the injunction by the order dated 28/10/2021. To the effect that the defendants were restrained from changing the nature and feature of the suit land with the disposal of the suit. Being agreed, an appeal was prepared, being Miss Appeal number 6 of the 2021 before the court of the civil judge Hailakandi. In the said appeal, the learned trial court, first appellate court, set aside the order of injunction on the ground that as the plaintiffs were not in possession of the suit land. The injunction not to change the nature and feature of the suit land ought not to have been passed by the learned trial court. It is therefore against the said order dated 24/2/2021 passed by the learned first appellate court in Miss Appeal number 6/2021. The present proceedings have been initiated. I've heard Mr. M.J. Kadir, the learned counsel appearing on behalf of the petitioner, and Mr. S.K. Ghosh appearing on behalf of the respondent. The learned counsel for the petitioner had duly submitted that the petitioners were dispossessed on 10/12/2020 and they have been in possession of the suit land since
1987.
1987. 1987. Therefore, as rights have been created in respect to the land of the petitioner, in respect to the suit land, the petitioners could not have been evicted in a manner not envisaged in the law. Under such circumstances, the learned counsel further submitted that in the circumstance, the nature and feature of the suit land, it changed. It would cause irreparable loss or harm and injury to the petitioner, which the learned first appellate court did not consider. Further to that, the learned counsel also submitted that the balance of convenience was also in favor of the petition, which the learned first appellate court failed to take into consideration. Mr. S.K. Ghosh, appearing on behalf of the respondent, submit that the respondents out here, the respondents were in possession of the suit land all along on the basis of a purchase
By constructing dwelling house.
and by constructing dwelling house. He submitted that the entire case of the petitioner is fictitious and based on imaginary cause of action. He further submitted that though it is the mandate of Section 6 of the Specific Relief Act 1963 for disposal of the such proceeding initiated under the state provision within a period of 6 months, but the petitioner, as plaintiffs, have been delaying the state disposal until date have not submitted the evidence.
Yes, and earlier ex parte order was passed, then it was vacated at cost. Now last date they have submitted the cost.
The
And
evidence
now-
has he given.
Not given.
I've heard the learned counsel appearing on behalf of the plaintiff, on behalf of petitioner, as well as the respondent, and taking into account the above mentioned submission. From the materials on record, it transpires that the respondent herein are in possession of the suit land. It is the specific case of the petitioners in the plaint which is yet to be adjudicated, that the petitioners have been in possession of the suit land, and on 10/12/2020, the petitioners were dispossessed by the defendants, and within the period as stipulated in section 6.2 of the Specific Relief Act 1963, the suit was filed. The only prayer for injunction which have been sought for is that the defendant should not change the nature and feature of the suit plan, and which the learned trial court have granted by the order dated 28/10/2021. This court has also taken note of that the exercise of jurisdiction by the trial court is an exercise of an equitable and discretionary jurisdiction. The appeal thereagainst which have been filed is actually an appeal in principle, and the first appellate court jurisdiction is limited to the extent that if the order passed by the learned trial court, the learned court of the learned trial court, that is the first court taking up the injunction proceeding, is unreasonable, arbitrary, irrational, perverse, and against the well-settled principles for grant of an injunction. This court have duly perused the order dated passed by the learned first appellate court, and merely on the ground that the petitioner is not in possession of the suit land, have rejected have set aside the order passed by the learned trial court dated 28/10/2021. In the opinion of this court, the state order passed by the learned first appellate court requires an interference, as the exercise of the jurisdiction carried out by the learned first appellate court was contrary to the well-settled principle as aforementioned. Accordingly, this court therefore sets aside the order dated 24/2/2022 passed in Miss Appeal number 6 of 2021, and thereby restoring the order dated 28/10/2021 passed in Miss case number 5 of 2024 by the learned trial Munsif number 8. Before parting with the record, this court, however, also finds it very pertinent to take note of the submission of Mr. S.K. Ghosh, the learned counsel appearing on behalf of the respondent, who submits that although the said application, the suit was filed in the year 2021, and almost 3 years have, and even after a period of 3 years, the said suit have not been disposed of. This court, taking into account the mandate of section 6(3), what is that? 6(3), 6 months. Specific relief act. You have it, both of you? Both of you are appearing without a specific relief act. And you are doing a case, Mr. Kadil, of a specific relief act. I hope you have seen that provision. Yes, under 6(3). Submitted that these are proceedings of the section 6 of the before concluding, this court finds it very relevant to take note of the submission of Mr. S.K. Ghosh, the learned counsel appearing on behalf of the respondent, that the suit was sued under Section 6 of the Specific Relief Act 1963 was filed in the year 2021 and till date. The plaintiff have not filed the evidence, and as such, the delay in disposal of the state suit, and there has been therefore a delay in disposal of the state suit, which is affecting the rights of the defendants. This court having taken into account the provisions of Section 6, wherein the only issue involved is as to whether, wherein the question which requires to be decided are primarily as to whether the said suit has been filed within the time stipulated in Section 6(2) of the Act of 1963. And the second question which arises is as to whether the petition plaintiff were in possession within 6 months from the date of the filing of the suit. Under such circumstances, this court requests the learned trial court to dispose of the state suit as early as possible, preferably within a period of 7 months from today, from the date, from the date. There's a stay of the suit? No.
No.
In view of the above order, the interim order of status quo, and in view of the order passed, it is before this court further clarifies that the order passed by the learned trial court dated 28/10/2021, passed in Mizze case number 5/2021, stands restored. In fact, it has been wrongly shown, although it has been shown as here. We'll take it up as orders.
Here is the This is a transfer petition, Lordship, for transfer of a divorce to Lordship pending in the court of Principal Judge Nalbari to the Principal Judge Borketa. Okay, what is
You are the petitioner in
that?
Item 40.
40.
40, transfer
Yes.
petition 40. And you are the petitioner in transfer petition 73.
My lord,
You are the wife?
my lord.
You are the husband.
Yes. In fact,
You want it where?
both the parties are residing in Borpeta. Now, on the pretext that she is serving in Nalbari, she has filed this petition for divorce around 42 kilometers from her permanent residence. And she commutes to her place of service daily. She is staying in her permanent residence, which is mentioned in a divorce petition at Hela, Borpeta. Now, both of us are permanent resident of Borpeta district, Lordship. Now, I find no reason why she had to file this petition for divorce at a distance of around 42 kilometers from her permanent place of residence. Both of them
No.
resided together in Borpeta.
And
No,
what is your case?
I have filed a divorce case as because I have been now a subject teacher in the Raghunath Chaudhary High Secondary School at Nalbari. And there I have filed, since there I was now in a rented house from June 2022. So there I have filed a divorce application. And from my place of residence, the Nalbari court is around 4 kilometers. within. And on that basis, my lord, I have filed a divorce application.
There are two
And-
cases.
Yes, yes, one filed by them and one filed by. In Borpeta, there is no one is there in Borpeta, no one is there. My parents is also not in Borpeta.
How the notice could be.
And only I am in Nalbari, my lord. I stated in my paragraph also the ID and the joining in the school.
We have served a copy of the notice issued by this honorable court at Borpeta in a
Because
permanent basis.
in Nalbari, my lord, after filing the divorce application, they have appeared and filed their WS also. And while this honorable court has passed the interim order saying the divorce application proceedings, my lord, they have also appeared before the counselor also, and there they have submitted the honorable court stay order. Lordship will find. My objection in page 41, they have filed their WS. They have appeared there in Nalbari matter.
You have been residing in Nalbari since when?
June 2022 onward. My lord will find
And your divorce petition is at Nalbari.
my lord,
Pending.
my lord.
And the other petition is for
Restitution.
Restitution they have filed after getting the stay order from this court, my lord. Thereafter, they have filed the restitution case at Borpeta. And we are praying for that to transfer to the Nalbari,
so this is the first case, Nalbari.
my lord.
But there you have given the address as Borpeta.
Borpeta, my lord, in the Nalbari case, my lord,
Tomorrow, if you have to go again back, you're working as what?
subject teacher, my lord. In the
How?
Raghunath High Secondary School, my lord, Kotani, my lord. Now, in page 20, in my item number 41, the current address has been given, my lord.
Hmm?
In my divorce application, current address has been given. On that basis, I have filed the divorce application.
Both the application, transfer applications are taken up for disposal by this common order. The petitioners in both the petitions are husband and wife. No, but the parties before this court in both the petitions are husband and wife. But on account of matrimonial dispute, they are separately residing. The petitioner in transfer petition number 73/2023, who is the wife, filed a divorce application, filed a suit for divorce under section 31 bracket IA of the Hindu Marriage Act 1955, 1955, 55 or 95? 55. Before the principal judge at Nalbari. The same proceedings have been registered as matrimonial divorce What is the number?
The 38 of 2023.
38 or on top it is something written as 28. Are you sure?
Yes, 38, my lord, page 20, my lord.
Kindly see 38 on top. What is it? 38.
Yes, yes.
Matrimonial to bracket D 38 of the 2023. The said application was filed on 9th of February 2023.
Right.
In the said proceeding, the husband, who is the petitioner in WPC number 40, in transfer petition number 40/2023, have also filed their written statement on
12/5,
12/5/2023.
23.
The record of both the cases further reveal that the husband filed a suit for restitution of conjugal rights. Thereupon, on 19/5/2023, this was filed before the Principal Judge, Family Court, Borpeta. It is further relevant to mention that prior to filing the said suit by the husband filed the transfer petition C 40/2023 before this court, and this court, by an order dated 17/5/2023, state the further proceedings of matrimonial suit D 38/2023, which was pending before the Principal Judge, Family Court in Albany. Pursuant to the filing of the suit by the husband, that is Sri Anjan Kumar Oza, the petitioner in the wife, that is the petitioner in transfer petition number 73/2023, instituted the same proceedings for transfer of the suit, being TSMFC number 153/2023 to the Court of the Principal Judge, Family Court, Nalbari. Under such circumstances, both the matters are taken up analogously by this court, and the learned counsel appearing on behalf of the parties are duly heard. From the materials on record, it reveals that the wife, reveals that the petitioner in the transfer petition number 73/2023 have instituted the proceedings for divorce first at Nalbari. On 9/2/2023, The petitioner in WPC in transfer petition number 40/2023, that is the husband, have duly participated in the said proceedings and filed the written statement. Subsequent thereto, transfer petition number 40/2023 was filed and a stay order was obtained from this court on 17/5/2023. Immediately thereupon, the petitioner in transfer petition number 40/2023 filed the proceedings for restitution of conjugal rights being transferred to TSMFC 153/2023 before the Principal Judge Family Court Borpeta on 19/5/2023. This court is of the opinion that as the first proceeding was initiated at the before the court of the Principal Judge Family Court at Nalbari, that is matrimonial case divorce 38/2023. The second proceedings ought to have been filed by the husband at before the Principal Judge Family Court Nalbari, more so taking into account Section 19 of the Hindu Marriage Act 1955. Under such circumstances, this court transferred TS-MFC number 153/2023 pending before the court of the Principal Judge Family Court Borpeta to the court of the learned Principal Judge Family Court Nalbari. The registry is directed to intimate both the courts below about the instant order forthwith. This court further directs the Principal Judge Family Court Borpeta to immediately transmit the records of TSMFC number 153/2023 to the court of the Principal Judge Family Court at Nalbari. This court further takes note of that as both the matters are interrelated, the learned court of the Principal Judge Family Court at Nalbari shall take up both the matters, shall decide both the suits analogously. It is seen that the petitioner, during the course of the hearing, this court had made a pointed query upon the learned counsel appearing on behalf of the wife, that is petitioner in transfer petition number 73/2023 as to whether the said petitioner had filed a written statement, and he submitted that he has not filed the written statement and had approached this court immediately after receipt of the summons. Taking into account the above, this court fixes the matter on 1st of May, maybe 2nd of May before the court of the Principal Judge Nalbari, wherein the petitioner wherein the wife, that is the Bonita Talukdar, shall file her written statement in the said in TSMFC 153/2023 without fail. The court of the principal, the learned court of the principal judge, family court, Nalbari, shall thereupon proceed with the disposal of both the suit analogous stay as directed above and in accordance.
Lordship
The interim order passed earlier. That take it.
Lordship has observed else in Nalbari. I think it should be Borpeta.
Huh?
Principal Judge Borpeta.
I've transferred it to
Nalbari.
not perfect.
All right.
In fact, I should impose cost upon for unnecessarily filing it out there. You knew there is a proceeding out there.
No, both of us are residing nearby, Lordship.
But
within the
nearby you are
jurisdiction of
residing, you know,
Borpeta district.
forget about that. The matter is that she stays out there, you know it, being the husband, where she stays. He has categorically mentioned in the transfer petition, in the her divorce petition that she is presently residing at Nalbari.
That Lordship, he commutes to her place of service daily. She comes back home to a permanent place of
He
residence.
categorically has mentioned out there. Have you
What is
denied
that,
it in your written statement that she doesn't stay there? No. Can you file it out after getting a stay? Okay, we impose a cost of 55,000.
No,
This type of litigation is not encouraged.
Item 42.
All right.
Yes, what is this?
Application for rejection of the plaint was rejected.
Your plaint was rejected,
The application for rejection of the plaint under Order 711D
was rejected.
the plaint was filed, my lord, page 32 order. That's it was filed by the auction.
What is your application under section 13?
The Order 711 application is at page 50.
What was the suit for?
No, the suit was for declaration, partition, and injunction.
Not partition.
I'm sorry,
Remedies.
declaration and injunction.
Suit for
Not it.
declaration and injunction. Who are the parties?
And my lord, the suit was filed by an
Pony
auction
Purva,
purchaser.
branch manager, Northeast Agro Construction, Uco Bank, Haripute. And as per the terms of the auction notice to now, who has taken the loan?
My lord, the loan was taken by the performer respondent number 2.
Then
Performer respondent number 2 took a loan, defaulted, my lord, proceedings under the SRPSI Act were initiated. Thereafter, my lord, in pursuance of the same, my lord, the property was sold in an e-auction. The plaintiff, my lord, this respondent, he was the auction purchaser, successful auction purchaser that auction.
pursuant to a surface proceeding.
Surface act. And my lord, when the time came to take the physical possession, the date of physical possession, my lord, what happened was that the guarantor in the loan, he on the very same day in the presence of the executive magistrate, my lord, settled the matter by paying up the entire outstanding due. Thereupon, my lord, the bank had no option but to cancel the auction and refund his money. My lord, he filed this suit claiming that I am entitled, but his declaratory right is there in respect of that auction property. And consequently, also the claim for damages of 45 lakh. Basically,
Then-
his claim, if your lordship comes to page 37, how he has calculated what he basically claimed.
Then?
Lordship will kindly come to page 37, that is the para 12, internal para 12 of the claim.
Then
And my lord, his claim of damages is 45 lakhs, 40,000, etc. my lord, and that your lordship sees, my lord, he sees in para 12A illegally accepted amount of rupees 1.
Then tell me.
Yes.
What is your application?
So that the application, my lord, we have filed, that is at page 50 onward. My lord, in that application, we say that anything, because it pertains essentially, my lord, to a claim relating to an auction under the SRPSI Act. Supreme Court has settled very clearly, my lord, that the jurisdiction of the DRT starts with the first measure under 13.4 and ends with Rule 9, whatever happens in Rule 9 of security interest enforcement rules. Here, my lord, the learned trial court has overlooked that part. That anything and everything that arises out of the auction, including whether the amount of the deposited by the
Where
auction.
then, when did a cause of action happen for him?
For him, my lord, on the day, my lord, when the bank returned his money and
cancel the
No.
auction.
His cause of action happened pursuant to Rule 9.
Yes.
Rule 9 is for sale.
Yes, sale.
So you'll exercise the sale, you sold it to him.
No, my lord, the sale was not complete because the sale certificate was not issued. The sale certificate, had the sale certificate been issued, then the matter would have been complete under Rule 9 also. Because Rule 9 says, my lord, that the certificate of sale will be delivered, and along with that, the property will also be delivered to the, your lordship will kindly have, my lord. My lord, there are 3 relevant sections there which are also important. Lordship will kindly have the Sarveta Act.
Yes.
Lordship will come to section 17.
Yes.
Now, section 17, my lord, the application against measures to recover secured debts. Any person, including borrower, agreed by any of the measures referred to in subsection 4 of section 13, taken by the secured creditor or his authorized officer under this chapter, may make an application so and so to the debts recovery tribunal having jurisdiction in the matter within 45 days from the date on which such measures have been taken. Well, 17 makes it clear that any person, whether it is the borrower or any person who is aggrieved by anything that happens by under section 13. And I will submit that 13.4, these measures start with 13.4 and ends with what happens in rule.
No.
Yes, Lordship will, then, my lord, Lordship will kindly have section 19.
No, we'll look into that. 13.4. In case the borrower fails to discharge his liability
Yes.
in full within the period specified demand, the secured creditor may take recourse to one or more of the following measures to recover his debt,
Yes.
namely, take over the possession, take over the management, provided that the right to transfer by way of these so and so. Then appoint any person.
Yes.
Appoint any person so and so. Require at any time by notice in writing any person who have acquired any of the secured assets. Now see.
Yes.
Require at any time by notice in writing any person who have acquired any of the from the borrower or from whom any money is due or from any due so and so to pay to the creditor so much of money. Any payment made by so and so. Then how do you bring in 13.4?
No, these are A, B, C, D, 13.4 covers
No.
a range of things.
Then
Now, Lordship will kindly have
17 does not apply.
yes, 17, my lord, and the also, my lord, section 19. Section 19 was also amended, my lord, in 2004.
Right of the borrower to receive
Yes,
compensation.
but now
of
the
costs in certificate.
definition of borrower has been expanded.
This is different.
No, it applies. If
You
you find it, if the
you
debts
would not
recovery
come out
tribunal
with-
or the court of district judge on an application made under section 17 or section 17A of the Appellate or the High Court or on an appeal preferred under section 18 or
I agree
section
that.
18A holds that the possession of secured assets by the secured creditors is not in accordance with the provisions of this act and rules made and directs the secured creditors to return such assets to the concerned borrowers or any other aggrieved person who has filed the application under section 17 or section 18. So, borrower or any other aggrieved person. And my lord, section 34, Lordship, the civil code jurisdiction is part. Now, if your Lordship will kindly come to the rules. The security interest enforcement rules. 1000.
Not that it.
But
This is an application.
Lordship will,
No,
there are judgments to
no.
judgment to the Supreme Court, my lord, to this
Let
effect.
then go to Supreme Court. It is an application under section 115 of the Code of Civil Procedure 1908, challenging for short the court, challenging the order dated 28/4/2023 passed by the learned civil judge number 2, Kamrup Metro at Guwahati, in petition number 1703 of the 2022, arising out of title suit number 177 of the 2022. By the said impugned order, the application which was filed by the petitioner under Order 7, Rule 11D of the CPC was rejected, or the court was rejected. For deciding as to whether the said rejection by the impugned order, rejection of the application for rejection of the plaint, the rejection of the application by the impugned order was justified, was can be interfered with in the instant proceedings under section 115 of the code. This court finds it relevant to take note of the brief facts which led to the filing of the suit. The respondent herein, who was as a plaintiff, had filed title suit number 177/2022. The facts enumerated in the said suit is that the respondent number one, the defendant number one had issued a sale auction, had issued an e-auction sale notice for sale of 4 numbers of immovable properties under the Securitization and Reconstruction of Financial Assets and Enforcement of Security Interest Act 2002, read for short the Act of 2002, read with the proviso to Rule 8(6) of the Securitization Interest of the security interest, security interest bracket enforcement rules 2002, for short the rules of 2002, on 23/12/2020 by publishing the same in a newspaper. The plaintiff, upon perusal of the same advertisement, participated in the online question bid in respect to one of the properties to be auctioned, which have been specifically defined, described in Schedule A to the plaintiff. The plaintiff thereupon participated, upon participation of the plaintiff, he became the highest bidder by bidding an amount of rupees 75,60,000 for the property described in Schedule A. Under such circumstances, the plaintiff received an email on 30/1/2021 at 7:05 p.m. with the title, say inverted comma, sale intimation letter, inverted comma, close, confirming that the quoted amount of 75,60,000 for the property described in Schedule A and also stating therein that the status of the lot is subject to approved bracket STA. Subsequent thereto, another email was received at 7:32 p.m. from the authorized officer of the defendant number 1, who is the defendant number 2 in the suit, which contained details regarding the e-auction and the acceptance of the same as the highest bidder, and accordingly declared as inverted comma HI bidder for the said property, inverted comma closed. The plaintiff thereupon was required to deposit 25% of the bid amount, which came to rupees 18,90,000. Apart from that, the plaintiff was also directed by a message by the defendant number 1 and 2 to deposit the remaining 75% of the entire bid amount within 15 days, that is on or before 14/2/2021, in the account provided by the defendant. It was also mentioned that in the circumstance the plaintiff failed to deposit the said amount, it would result in cancellation of the sale, and any amount deposited relating to the bid shall be considered to be forfeited. The plaintiff thereupon deposited 13,78,000 on 1/2/2021, and on 12/2/2021 deposited the remaining 56,70,000. And therefore, in total, had deposited as on 12/2/2021, 75,60,000. The confirmation of the payments made on 1/2/2021 and 12/2/2021 was duly communicated by letter dated 17/2/2021, which was sent by the defendant number 1. Thereupon, the plaintiff was asked on 2/9/2021 to be present on the spot of the mortgage property, that is the Schedule A property, on 4/9/2021. That is the date by which the learned magistrate, for bestowing the physical possession of the mortgage property to the plaintiff, however, on that day, the plaintiff could not visit. Be that as it may, a letter was written to the plaintiff dated 6/9/2021 by the defendant number 1 and 2, stating inter alia that the bank, that on 4/9/2021, in absence of the plaintiff, the defendant bank, along with the learned magistrate and other police personnel, reached at the spot for taking physical possession of the mortgage property. However, as the guarantor, one Sri Dharnia Ram Coach had offered a compromise proposal for rupees 1,00,000,5 lakh on the spot for settlement of the NPA of the performer respondent number 3, performer defendant number 3, and also deposited the said sum in the no lien account, alleging inter alia that there was mass agitation against the physical possession as the guarantor wanted to settle the loan account. So the learned magistrate refused to take physical possession of the mortgage property, taking into consideration the apprehended breach of peace and tranquility and law or order situation as claimed by the bank. It was therefore the case of the plaintiff that as the plaintiff had duly paid the amount and the respondent have also accepted the said amount, the respondent and the defendant have duly accepted the defendant bank had duly accepted the backup, and the defendant bank cannot now reside for which the suit was filed seeking very declaration to that effect that the residing that the cancelling of the auction sale by the defendant bank was highly illegal and without just cause, for which the plaintiff was entitled to compensation as claimed for in the suit. Isn't that, Mr. Tattar?
Yes, my lord.
On the basis of the say, the pursuant to the issuance of summons, a written statement was filed by the defendant number 1 and 2. In the said written statement, yes, who has filed this written statement? This person doesn't know how to file a written statement. Denying to the entitlement of the plaintiff to the claim for damages. And also raise the issue of maintainability of the suit in view of Section 34 of the Act of 2002. The said written statement was filed on 10th of June 2022. On the same day, an application was filed under Order 7, Rule 11 for rejection of the plaint on the ground that the suit was barred under Section 34 of the Act of 2002. To the said objection, to the said application seeking rejection of the plaint, the plaintiff duly filed a written objection.
Yes.
On the basis of the above, the learned trial court, by an order dated 28/4/2023, rejected the application filed by the defendant numbers 1 and 2 for rejection of the plaint under Order 7, Rule 11. Holding inter alia, that from the relief sought for in the suit and the statements in the plaint, it revealed that the suit is a declaratory suit along with consequential relief in the form of damages and compensation. It was also observed that from the averments made in the plaint, the suit was not filed against any of the action taken by the secured creditor in terms with Section 13(4) of the Act of 2002. And as such, the bar imposed by Section 34 of the Act of 2002 cannot be made applicable. Being aggrieved by the impugned order, the instant application has been filed under Section 115 of the Code. In the backdrop of the above, let this court take note of the submissions made by the learned counsel appearing on behalf of the party. Mr. A. Ganguly, the learned counsel appearing on behalf of the petitioner, submitted that a perusal of Section 13(4) read with Section 17 would show
And 19.
we'll come to 19 later. We'll come to 70 would show that if any person is aggrieved with any action, any measures taken under Section 13(4) by the secured creditor or his authorized officer, he may take the said person may make an application to the debt recovery tribunal having the jurisdiction in the matter within 45 days from the date on which the measures have been taken. Further, the learned counsel further drew the attention of this court to Section 19 of the Act of 2022, which gives a remedy to the borrower or any other aggrieved person who had filed an application under Section 17 or Section 17A or appeal under Section 18 or Section 18A, as the case may be, for payment of compensation and cost as may be determined by the tribunal or the court of the district judge or the appellate tribunal or the high court referred to in Section 18B. The learned counsel, therefore, for the petitioner therefore submitted that in view of section and in view of the action complained in the plaint comes within the ambit of section 13(4). The remedy, therefore, of the plaintiff would have been under section 17 as well as section 19 of the Act of 2002 and not by filing a suit. We further submitted that section 34 would clearly show that when the remedy lies before the Debt Recovery Tribunal or the Appellate Tribunal empowered under the Act of 2002, the civil court cannot entertain any suit or any proceedings. He therefore submitted that on the face of it, from a perusal of the statement made in the plaint, the suit was barred under section 34 of the Act of 2002.
Rule 9. Rule 9 of not part. The court read with the section 17 and section 19 say that 34 measures under 13(4) and the rules also there.
Well, who says?
The measures under rule 8 and 9 are the procedural measures. But the court has said that action, the jurisdiction of the tribunal starts with that ends with whatever happens under rule 9, with the delivery of possession and the issuance of the said. I can, Your Lordship, hand over that.
Show me that.
First one is followed Agarwal Tracom's case that I think
Yeah, what did it say?
have page 171. Short question that arises for consideration in this appeal is whether the High Court was justified in holding that the remedy of the appellate auction purchaser lies in challenging the action of the secured trader in forfeiting the deposit by filing an application under section 17 of the Sarkisai Act for the DRT, or the remedy of auction purchaser is in filing the petition under Article 27 of the Constitution to examine the legality of such action. So, refers to section 13(4) and section 17. Lordship, kindly subscribe this part of the 19 of there are 20. Section 13(4) is invoked by the secured trader against their borrower when the borrower fails to discharge his liability in full within the specified time. Secured trader then can take possession of the assets of the borrower, transfer the assets by lease or by assignment, or sell the assets to recover the outstanding fees under clause A. Then below the A, B, C, D, everything is discussed. Now it's para 23. So far as section 17 is concerned, it provides the remedy to a person to agree by the measures taken by the secured trader or his authorized officer under section 13(4). In relation to secured assets of the borrower, it says that any person, including borrower, may make an application to the DRT within 45 days to the date of measures taken under section 13. Subsection 2 of section 17 was added by way of amendment. It provides the tribunal on such application being made under section 17 shall consider whether the measures taken referred to and taken under section 13(4) by the secured trader are in accordance with the provisions of this act and the rules made thereon. Similarly, subsections 3, 4, and 7 of section 17, which deal with the power of the DRT, also use the expression in accordance with the provisions of the act and the rules made hereon. Rule 8, which has 8 sub-rules, deal with the manner of sale of immovable secured assets and provides detailed procedure as to how, in what manner, the sale of secured assets is held. Rule 9 deals with time of sale, issue of sale certificate, and delivery of possession. Rule 9(6) empowers the authorized officer to issue sales certificate in favor of purchase. Rule 9(9) then empowers the authorized officer to deliver the property to the purchaser, whereas Rule 9(10) empowers the authorized officer to mention in sales certificate that the property is free from encumbrance. So far as this is concerned, sub-rule 5 of Rule 9 is relevant. It provides that if the auction purchaser commits any default in payment of sale consideration within time specified, the deposit made by auction purchaser shall be forfeited. The secured creditor and the auction property shall be sold, and the defaulting purchaser shall forfeit all claims to the property or its part of the sum for which it may be sold subsequently. Reading of the aforementioned sections and the rules, and in particular section 17(2) and 9(5), would clearly go to show that an action of secured creditor in forfeiting the deposit made by the auction purchaser is part of the measures taken by the secured creditor under section 34. The reason is that section 17(2) empowers the tribunal to examine all the issues arising out of the measures taken under section 34, including the measures taken by the secured creditor under the rules 8 and 9 for disposal of the secured assets of the borrower. The expression provisions of this act and the rules made thereon, occurring in subsections 2, 3, 4, and 7 of section 17, clearly suggests that it includes the action taken under section 34, as also includes therein the action taken under rules 8 and 9, which deal with the completion of sale of the secured assets. In other words, the measures taken under section 13(4) would not be completed unless the entire procedure laid down in rules 8 and 9 for sale of the secured assets fully complied with.
See, kindly come to paragraph 29 of that.
Sure.
Here was a case where it was forfeited
Sure.
by on the ground that the auction purchaser did not make the payment. Therefore, it came under 9(5).
Yes, right.
Here is not a case of forfeiting.
No, we are not on the issue of forfeit at all.
This is not a case of forfeiting. It is the case where you have not made the payment, not delivered whatever you are resigning from your promise.
My lord, that is precisely my point, my lord. Rule 9 requires that the delivery of possession without encumbrances.
Too far-fetched by this. And where is the other one? What is
The other one is regarding the fact that any person, including a borrower, can.
Borrower is okay, but how do you bring in somebody else?
Here was a case, my lord. In this case, my lord, I think aware of this. This was a
And
case
this was a
by-
proceeding under 227, 226.
Yeah.
That proceeding was
Yes.
under proceeding
Yes.
under 226.
Yeah. So the
Not a proceeding under Order 7, Rule 11.
No.
And not a proceeding under 34.
no, that is not there. But the fact remains that
You see, the Supreme Court went into the question of 17(2) of forfeiting of a year which is a part of it.
Yeah.
And said about any person.
here also, my lord,
In fact, that is too far-fetched. Can't help it.
in order to, my lord, arrive at the issue of compensation or damages, the finding will have to be given by the civil court that the action of the secured creditor in cancelling the sale is wrongful. My lord. Without that, the question of damages and compensation, it might
That is why he is asking for that declaration.
my lord, that declaration, my lord, that finding, in order to go into that question, my lord, the civil court will have to go into the issue of the correctness of the auction procedure, right up to the issue of the my lord's cancellation of the auction. So anything that arises out of the auction, my lord, he can, because my lord, the issue is here. I'm not saying he doesn't have a remedy. He has a remedy, but his remedy, my lord, lies in the tribunal. In fact, it's a more efficacious remedy, because my lord, the tribunal within 4 months can go into the issue of whether the action of the secured creditor was wrongful or not. If it is wrongful, my lord, section 19 and even otherwise under section 17 also, tribunal has sufficient powers to grant compensation to him as his claim. The issue is not that this civil court, my lord, cannot go, my lord, in a declaratory suit under 34, yes. But the issue is here, my lord, the action of the secured creditor was surely, my lord, under Rule 9. Because Rule 9, as the lordship sees, my lord, Rule 9 sub-Rule 10 ends with the delivery of possession without encumbrances, my lord, to the auction purchaser and issuance of the certificate of sale. That is my point. That unless and until the certificate of sale is issued, Rule 9 doesn't end. So the point here is whether his action of the secured creditor is wrong. That finding will have to be given by the civil court. Now, that jurisdiction is only of the tribunal. And that is why the scope, if your lordship notices, my lord, in 2016, the amendments, the scope of borrower has been now expanded. Borrower or any other aggrieved person. So, my lord, he cannot say that, no, I am not an aggrieved person, I cannot go to the DRT. Yes, my lord, he can go into the DRT. It is for the DRT to adjudicate, my lord, whether the action of the secured creditor was wrongful or not. If it was wrongful, my lord, the DRT is well empowered, my lord, granting compensation. It need not grant him, my lord, the civil court, my lord, is definitely required to go into the question because that declaration that he's seeking, the decree, that my lord, will adjudicate the issue of the cancellation of auction, whether the bank was right in cancelling the auction. He may have a good case on merit, my lord, but that case lies before the tribunal. That is the facts of the question. It's not that he doesn't have a remedy, or it is not a case of Order 7 Rule 11A, my lord. It is a case of Order 7 Rule 11B. I'm not saying that he doesn't have a cause of action. He has. That cause of action, my lord, arises not before the civil court, arises because in the DRT, because the Supreme Court, my lord, has said that measures, my lord, starts with 13.4, ends with Rule 9. And that is my submission, my lord. Rule 9 has the entire procedure ending with the delivery of the possession of the property without encumbrances and issuance of the sale certificate.
Yes, what do you say, Mr. Sir?
My lord, declaration cannot be adjudicated by the.
The declaration is only for main thing is actually for damage.
Yeah.
Now, what do you say on that? What do you say about that, Judge?
Damages can also not be assessed by the DRT. Damages cannot be assessed by the DRT.
Oh, you can be at 19.
My lord?
Under 19.
Yes. Under section 19 of the SRPC, my lord.
It was the case on the
My lord, 19 says about the right of borrower to receive compensation and cost in certain cases. My lord, I do not fall under the head borrower. I am not borrower, my lord.
No. People.
Yes.
But down the door.
Yes, my lord. If the debts recovery tribunal or the court of the district judge or an application made under section 17 or section 17A of the appellate tribunal or the high court on an appeal preferred under section 18 or section 18A holds that the possession of secured assets by the secured creditor is not in accordance with the provisions of this act and rules made thereunder, and directs the secured creditors to return such secured asset to the concerned borrower or other aggrieved person who has filed the application under section 17 or section 17A or appeal under section 18 or section 18A, as the case may be, the borrower or such other person shall be entitled to the payment of the such compensation and cost. My lord, in my respectful submission before your lordship, this borrower or such other persons falling under that category, not the auction purchaser. Concerned borrowers or any other aggrieved person who has filed the application under section 7.
Yes.
My lord, in my
No, why do you want to go first if they say the 17 is there?
my lord, there if I go, my lord, I shall have to pay the 50% of the amount.
You don't have to pay. Question of you paying does not arise. You don't have any due. Question of you paying, you are not going to pay. You are only asking that
200.
if you have.
As per the schedule, 200 rupees.
Huh?
As per the schedule, 200 rupees.
But if you only 200 rupees, here you are paying so much, 11,000.
Yes.
Then how does it help you?
But my lord, this section 18, 19, which he is taking recourse to, my lord, actually, in fact, my lord, so for my respectful submission before your lordship is concerned borrower or any other aggrieved person, concerned borrower is the person who has taken the loan, and the guarantor, my lord, only gets cover in.
No. Finally, 19 properly. Concerned borrower or any aggrieved person who has filed an application on the 17th.
Section 17 or 17A, or an appeal understand. Yes.
I think this may help you.
Section 17, my lord.
You go and file 17. He can oppose that because of this.
True.
Now, this period has to be excluded for filing the suit because this action happened then. So this direction, this court is going to give it to you.
Your lordship says that if your lordship feels that I am having the efficacious remedy therein before the tribunal.
And he can oppose that because it is a he has that.
Yes.
As to whether he can catch it or not for them. And that too, you have the backing of a high court order. That the jurisdiction is there. However, the jurisdiction point can't be there. Thereafter,
One more aspect of the matter, Para 12 he has made a very specific claim for damages. The tribunal doesn't have to calculate the damages. Either he is entitled to this 45 lakhs, whatever. So this is a liquidated damage that he has claimed. Either the tribunal grants him the damage or grants him perhaps. He can't say that the tribunal has to entertain evidence to calculate or such like thing. So
no, there will be evidence will be required. Because the
in the form of
loss.
summary.
No, he is asking for certain loss.
Yes. That he has quantified. That he has quantified.
No,
In Para 12.
he has quantified by himself. That's
Sure.
a different thing. The question is, can the trial court is not this quantification
So-
is there is a difference. illegally accepted amount of rupees so and so over the sold amount of demand and the balance thereof. So this 29 lakhs is asking. 29 lakhs is asking that you have that property now belongs to me. You have now again sold it. So therefore he answers this 29. Now this is the what you call the manner of calculation and not. And wouldn't that be the subject matter of the loss felt by him?
The loss claimed by him, he
Then physical anxiety and mental agony, loss of reputation and legitimate expectation, loss of time, business in fighting the case.
that's up to him to put before the tribunal. All questions may be examined by the tribunal. So the tribunal is not barred
Shall
from-
be entitled to the payment of such compensation and cost when it is permitted. We'll come back at you.
Oblige.
will be entitled to challenge the action of the secured creditor before the DRT by filing an application under Section 17(1) of the Act of 2002. Full stop. Paragraph number 22 to paragraph number 30 of the said judgment being relevant is reproduced hereunder. From the above observations of the Supreme Court, it would therefore be seen that the petitioner herein, or the respondent herein, who is the plaintiff, would come with, being an auction purchaser, would come within the ambit of his grievances as raised in the plaint, would come within the ambit of Section 17(1) of the Act of 2002. And as the said action would come within the ambit of Section 17(1) of the Act of 17 of the Act of 2002, there would be a bar under Section 34 for initiating, for filing a suit. Under such circumstances, this court is of the opinion that the learned trial court had erred in law in not rejecting the plaint in view of Section 34 of the Act of 2002, for which the impugned order dated 28/4/2023 is set aside and in view of the above observations, the plaint of title suit number 177/2002 is also rejected. This court further finds it also very pertinent now to take note of the submission of Mr. A. Sattar as regards the fees to be paid, as well as the period of limitation of 45 days. Mr. E. Gangoli, the learned counsel appearing on behalf of the respondent, submits, petitioner had submits that as there is no dues of the plaintiff oblique the respondent to the secured creditor, the applicable fees which have been prescribed is rupees 200.
Yes, but as per Rule 13 of the security,
What does it say?
but you kindly have to put 13. Fees for applications and
Oh,
yes, Rule 13 of the security interest code. There is a table, Malak. The amount of fee payable shall be followed. Under the entry E, any other application by any person. But it is, Malak, the others are all every party.
that means that it would come within the ambit of Section 13, Rule 13, 2E. And as such, the fee would be rupees 200. This court also have taken note of, taking it, this court have also perused the said Rule 13 of the rules of 2002. And from the said application, from the said table, it would be seen that the petitioner would come within the petitioner's application would come within the ambit of Rule 13E, 13(2)E. This court, on the question of limitation into this court, then this court have also duly taken note of that the plaintiff had filed a suit challenging the actions of the respondent, challenging the action of the defendants, and seeking declaration as well as for damages. Thereupon, the plaintiffs have been bona fidely and diligently pursuing the said remedies. It is on account of the order passed today. The plaintiff's suit, the plaint of the plaintiff have been rejected. Consequently, this court is of the opinion that the plaintiff is entitled to a reasonable period for filing the application under Section 17. Accordingly, this court grants the plaintiff 45 days from the date of today's order, from today, to prepare an application before the Debt Recovery Tribunal, Kamrup, Guwahati. Seeking the relief, seeking the benefits in terms with seeking remedies in terms with Section 17 and 19 of the Act of 2002. Next. Further to that, in addition to that, this court also finds it very pertinent to observe that the plaint having been rejected liberty is given to the petitioner plaintiff to file appropriate application before the learned trial court for the purpose of seeking refund of the court fee. With the above, the instant revision petition stands allowed with the above observations. Huh?
The tribunal will decide independent of the petition.
Which one?
Pertaining to Bhapna, finding that they may be there and the tribunal will decide it. Those observations may only for the purpose of.
Sorry, you have made the mistake. If I was their lawyer, I would have waited for another 15. Hello, what is this? None appears on behalf of the petitioner. Who is this? NM Deka. None has appeared on behalf of the petitioner on call. On the earlier occasion also, none has appeared on behalf of the petitioner on call, and this court adjourned the matter to be listed today. Under such circumstances, it seems that the petitioner is not interested in the instant proceedings, for which the instant proceeding stands dismissed for non-prosecution. The interim order which was passed on 13/9/2023 stands vacated, and the learned Principal Judge, Family Court Guwahati, shall proceed with the adjudication of FC civil number 539 of the 2023 in accordance with law. The registry shall intimate the court bill, the learned court below about the said order. Yes. Where's the other side?
But the petitioner, my lord, the wife, my lord, is staying at Guwahati, my lord. And the case was instituted by her husband at Borpeta, my lord. So, my lord, this petitioner praised for transferring the petition, my lord, at Guwahati, Kamrup Metro, my lord, the principal judge of that. Yeah, my lord, she has also a 1-year child, my lord.
How did you know about this petition?
Lord.
How did you know about the filing of the matrimonial case?
That my lord, on mobile, my lord, this notice was sent.
How? In the mobile?
Yes. WhatsApp. Lot of people will find at annexure 1, my lord. Directly, they did not serve. On mobile, they have sent this notice, my lord.
Yes, why did you file it there?
My lord, because they are staying there, my lord.
You are
She-
staying there,
she-
not Guwahati.
Not
No, no, at Borpeta, my lord. At Borpeta, my lord. Husband was staying there, my lord, and she voluntarily left, my lord.
Huh?
She voluntarily left, my lord. The matrimonial house, my lord.
You are staying in North Guwahati. North
North.
Guwahati is in Kamrup Metro.
Yes.
Rural, my lord.
Kamrup Metro.
Kamrup Rural.
No,
Rural.
Kamrup Metro.
How?
Yes, Kamrup Metro. I have repeatedly asked.
North Guwahati is in Kamrup
Not
Metro.
Guwahati, some part is rural and some part is. And even then now she has been shifted to now this, the wife and her father now shifted to Rani. They are setting at
How do I know?
that, but my lord, I have not that's the recent it was.
Then?
Even this Kamrup Metro, my lord, Lordship, I have kindly have a look at the address.
Yes, why did you file it there? At North Guwahati, at Borpeta.
Because the husband was staying, my lord, at Borpeta, my lord.
And where both of you resided earlier?
Borpeta, my lord.
Then?
My lord, now she has been forced to leave the house, and now my lord, he has dropped his petitioner at her house under compulsion, and now he has not taken. And rather, within a month, my lord, she has been dropped on 12th of April 2023, and in May, within a month, my lord, he has filed this. This lordship will find.
So you are opposing the divorce.
I have to oppose the divorce.
You don't want the divorce.
My lord, that part will be decided, my lord.
That is the most important thing.
Yes.
If you don't want the divorce, you want a divorce, very well. You need not contest. You only file an application there.
That is why, my lord, now since the petitioner as well as her 1-year child, they are leaving, my lord, and now she cannot go to the Borpeta,
Why?
taking her 1 month child, 1 year child. Now when the child was 3.5 months, my lord, she has been forced to leave the house. Somehow she is surviving with her mother, my lord, old-aged mother,
Where does the mother stay?
here in North Guwahati itself.
And why are you staying at Rani alone? If
No,
you are
Rani-
surviving with your mother.
No, now this mother and this mother was also the teacher, my lord. That is why they were residing here. The
And mother
not-
has
not-
retired.
already retired. No pension, nothing else, my lord.
So you stay in their parental house.
Yes,
So you have a house out there in North Guwahati.
this whole house, my lord.
So now you are going to a new house.
No. This is my lord. Just the earlier house was there, my lord.
So that means you have two houses, you have good money.
No, my lord,
Then
that is not the case, my lord.
that is the case. You have money.
No money, my lord. This since my lord, this is the old house, my lord, in the Rani. That just they are staying, my lord, for the time being. And the
Rani is somewhere else, not Guwahati is somewhere else.
no, my lord, for temporarily, my lord, they are residing for my lord, all these things, my lord.
Why you are staying
Now-
at Rani temporarily?
Rani, my lord, my lord, now she is jobless, my lord. Earlier she was working in a school, my lord. And because
So
of the,
North Guwahati is not your, it's not your house, or it's a rented property.
no,
Then-
it's a mother's house.
Then if you don't have a
Yes.
job, why you are not staying there?
But originally she is staying in North Guwahati,
Then
but sometimes she stayed Rani because of searching up the jobs, all these things, my lord. Because already
she has a job out there, Rani.
no, now she is searching, my lord. He is searching the job, my lord, because
She has gone to Rani for searching job.
my lord, this is this problem, my lord, sometimes to run here and there, my lord, this problem is going. Now, my lord, only fact remains, my lord, here, my lord, only the mother and this petitioner, and her 1 year time.
So let us do one thing. Let us admit this petition. Come up for hearing after 4 years. Then your child will also hear, then they will transfer it.
Already maintenance.
You also don't want a divorce.
No, that part, my lord.
You want a
my lord,
divorce.
let there be a contest, my lord, in the case, my lord. Whatever it is, my lord, it will be settled.
You don't want a divorce.
That part, my lord, I have not put my lord. Only,
Then you will
I'm
take your
only,
instructions on that. You have filed your objection? File it?
No, my lord.
File. This is a case which requires filing. 4 weeks time granted for filing objections. In time order, past earlier shall continue. Guilty.
The main respondent that we follow.
Hmm.
So that some of the proper response notice they may be stuck.
What is this matter about?
Matters we wait for some time for filing WF matter. They say that 90th
The
day.
defendants are debarred from filing written statement.
But advocate was deal, my lord, they could not get.
Plaintiffs were received on perusal of the evidence, the documents on by relied on by the plaintiffs were received by the defendants on 1/8, and therefore today is the 98th day. How? So 31st. 1/8, 1/9. The petition is therefore rejected. The defendants are debarred from filing. Suit for what?
My lord, other side for declaration partition.
Huh?
Partition. Declaration and partition.
And what are you? And Mr.
We are the main defendant.
Huh?
Main defendant.
Main defendant. That as per the
Speak for
family arrangement, the plaintiff. Oh, these are family properties.
Family part.
Perfect partition.
Perfect
Partition.
Partition, my lord, already affected, my lord. They have now
A
taken. my lord,
decree for perfect partition is a preliminary decree is asking. For the huge land. Hello. You are in possession.
My lord,
Are you in possession?
we are in position.
1 lakh?
My lord,
1 lakh?
home part.
We are concerned with 190
No,
bigas
no,
of
not
land.
the entire, my lord, not the entire.
190 bigas of
No,
land
only
at Romia.
Only partition property we are position.
Oh, okay, you give him 50% of the land. Instead of, there is no money, 1 lakh is too less.
No,
So
they are
50%.
positioning also land, my lord. They
You
are
want
also positioning
50%.
land.
How much you want? 50%.
Lord,
How much land do you want? 50%? Give her 50%. Don't pay cost. So we allow it subject to claiming that you have don't have a problem with 50% of the land to be given. You are happy with that?
Yes.
Okay. Okay, this is an application filed under Article 227 of the Constitution challenging the order dated 31/10/2023 passed by the Court of the Civil Judge Senior Division Kamrup, Aminga, whereby the petitioner herein
Principal defendant.
that is the defendant numbers 1, 2, 4 to 10, 12 and 20, 12 to 20 of the said suit were debarred from filing the written statement inasmuch as 90 days has elapsed pursuant to receipt of the documents by the said defendants. This court have duly taken note of the contents of the plaint, and from the said contents it reveals your relative
Yes.
that the suit which have been filed is a suit seeking partition of the properties described in Schedule A and Schedule A, Schedule B, and Schedule C. Of the plaint. It has been submitted by the learned counsel for the petitioner that on account of what? Why didn't you file?
Malati, we have given all the documents to the council to prepare the dossier, but the deal, Malati, could not prepare.
Submitted that all the documents were duly served upon, they were duly provided to the counsel appearing on behalf of the defendants. But the said counsel did not prepare the written statement. And it was on account of the fault of the said counsel. The said written statement could not be filed. This court have then taken note of the above and also heard the learned counsel appearing on behalf of the respondents, Mr. S. Sahu, who are the plaintiffs in the suit. The law is well settled that the provisions of Order 8, Rule 1 are directory in nature. However, it has also been held by the Supreme Court that it is only in exceptional circumstances the period of 90 days should be enlarged. This court have duly taken note of the submission made to the effect that it was the fault of the counsel of the plaintiff, of the defendants, for which the written statement could not be filed, and have also taken note of the submission of Mr. G.N. Sahavala, the senior counsel, that the written statement is ready and can be filed on the next date without fail. This court also finds that
Malati, next date is 22nd, my lord. So it may be after 2 weeks.
22nd you file it.
Malati, 120. Malati, if it got 2 weeks, Malati, if there, Malati, now, because the other council has not second text. They are somewhere in working somewhere, method, so they will call.
Why haven't you prepared the written statement?
So 2 weeks, my lord.
You have taken all the time now. Cost is 3 lakhs. No, this can't happen. The cost has to be compared.
Only
3 lakhs.
10 days, my lord. Maybe.
No 10 days. Either file it on 22nd or 3 lakhs. That submission of Mr. G.N. Sahavala, the learned counsel, senior counsel, appearing on behalf of the petitioners, that the written statement is ready and can be filed on such date as may be fixed by this court. He only submitted that on account of the defendants staying at various places, the said written statement submitted that the written statement the said written for the question submitted the written statement can be filed. However, he submitted that as the various defendants for who are the petitioners herein stay at various places, at least 7 days time may be given so that the said written statement could be filed after taking the necessary signatures from the said defendants. This court, upon hearing, is of the opinion that the impugned order dated 31/10/2023 is required to be interfered with for the ends of justice. More so, taking into account that the suit is a partition suit and the specific undertaking given by the learned senior counsel that within 7 days the said written statement would be filed. This court, however, is of the opinion that some cost has to be imposed upon the petitioners, in as much as on account of them the proceedings have been delayed. Accordingly, this court interferes with the order dated 31/10/2023 to the extent of only the petitioners, not others. Thereby granting liberty to all the defendants in the suit to file their written statement. All the defendants who have been served with the summons and thereby granting liberty to all the defendants who have suffered the order dated 31/10/2023 to file their written statement on 4th of April 2024. This court further imposes a cost of rupees. How many? How many petitioners? 22 petitioner, 10,000 each. No, 18 petitioner, 10,000 each, 1,80,000. Imposes a cost of rupees 75,000 upon the petitioners to which shall be deposited at the time of filing of the written statement on the date so fixed by this court. The plaintiffs would be at liberty to file an application for release of the before the learned trial court for release of the said amount, and the trial court shall pass appropriate orders thereupon. So the interim order which was passed on 24/11/2023 stands vacated, and the parties herein are directed to appear before the learned trial court on 4th of April 2024. Okay, 1 lakh.
Impugned order was of 31/10/23. Impugned order was of 31/10.
1 lakh. 75. No, one has to do it because what you have done, you were supposed to file as on 31/10/2000 something we had to file. As of now, another 6 months have gone. Whatever may be, you have to pay the price. You can't beat them. Yes, what is this? Yes, madam.
Transfer of judgment.
Other side, what has happened?
The
Service?
other side name shown in the
Learner has entered appeal on behalf of the sole respondent. Transfer from where to where? Kokrajhar to? Kokrajhar there to Dhupi. How far?
66
Huh?
6 kilometers.
66. Then
Without a-
why can't you go there?
She is a lady without any.
Lady?
She is a lady
Madam, it doesn't look nice.
without-
Don't you go out there to do cases outside? Personally, you. Don't you go to Nalbari, Borpeta to do cases? Then,
not act of.
and for that, a lady can go. Why can't you? Why can't she?
She has no income without.
Huh?
She has no income without.
Income nahi. What is the suit for?
Section 9. Section 9 is without.
Restitution. Allow go to site A appear go. For me. Allow go to for me. File your written statement on or before 6. Transfer from this court. Huh? Yes, Mr. Shah. Got your substantial questions of law?
Yes, Lordship.
Give it to me. Yes, what is this? Builder is what?
Lordship, I'm not the builder, not the promoter, your lordship. Just I have constructed my building, and out of hardship necessity, I
Huh?
have.
There was an agreement with you?
Yes, lordship.
Agreement for what?
Sale deed was executed already.
Huh?
Sale deed was executed in favor of the responding lord. Sale deed was executed in favor of the responding lordship.
Hmm.
But that sale deed was executed on good faith, being amount was paid to the appellant lordship, whereas that amount was not paid lordship. Remaining few months were left to be paid by the respondent to the appellant lordship, and for that another agreement was executed between the parties. My lord.
So what is the direction given for giving you that, for giving that parking space?
Parking.
Direction is given. We dismiss the appeal. Oh, have a case.
What, there is a substitution question is involved in this case. Lordship.
Okay. The instant appeal. I'm coming, huh? 5 minutes. Then I now think about the cost. Real Estate Record Regulation and Development Act 2016. For short, the RERA Act. From a perusal of the said section, it reveals that any person aggrieved by any decision or order of the Appellate Tribunal may file an appeal to the High Court within a period of 60 days from the date of communication of the decision or order of the Appellate Tribunal to him on any one or more of the grounds specified in Section 100 of the Code of Civil Procedure 1908. Under such circumstances, the entertaining for the purpose of entertaining the instant appeal, this court has to formulate a substantial question of law as is envisaged under section 104, 100(4) of the code. This code, by an order dated 19/3/2024, had asked the petitioner, appellant, to submit substantial question of the draft substantial questions of law on which the appellant bases its appeal. And accordingly, today, Mr. M. K. Shah had placed before this court 4 substantial questions of law which he proposes are involved in the instant appeal. The 4 substantial questions of law so proposed were 1, 2, 3, 4. Here it is there. Just write it. Okay. Next. For the purpose of deciding as to whether the above mentioned 4 substantial questions of law were proposed arises in the instant appeal, so that the said questions could be substantial questions of law could be formulated in terms with section 104, 100(4) of the code. This court takes up the facts in the appeal, facts involved in the instant appeal. From a perusal of the It is seen from a perusal of the memo of appeal that the appellant, for reasons best known, although have mentioned various enclosures to the memo of appeal, but none of the said enclosures have been enclosed. None of the said annexures have been enclosed. For reasons best known. In fact, when the matter was taken up on 19/3/2024, the learned, it was on account of the learned counsel appearing on behalf of the appellant that the impugned judgment and order dated 16/10 certified copy of the impugned judgment and order dated 16/10/2023 was placed before this court. Under such circumstances, on the basis of the materials available from the said impugned judgment and order, the facts are being discerned. Next. 3 complainants, that is Srimati Anju Mallu, Srimati Pinky Bansali, and Sri Mohan Lal Bed, had claimed that they had purchased 1 flat each, along with the car and scooter parking from the appellant. On 9th of September 2021, they filed a complaint with the Real Estate Regulatory Authority, RERA, alleging violation of the approved plan by the appellant, as he had constructed 3 numbers of 2-bedroom flats in the parking space and further constructed RCC rooms on the roof above the 2nd floor. The complainants also alleged in their complaint that the parking, water, drain, common space, electricity and security were not provided to them by the appellant. On the basis of the said complaint, a team consisting of the Secretary RERA, Town Planner RERA, and 2 GMC officials conducted a joint inspection of the site on 1/12/2021 on the directions of the RERA and submitted their report. It is also seen that on 27/9/2021, the appellant submitted his written statement stating inter alia that he had not provided a car parking space to one of the complainants, Srimati Pinky Bansali, as per Schedule B of the deed of sale signed by him with her. It was his claim in the written statement that the car parking was not provided to her as she had failed to pay rupees 5 lakhs, which she had agreed orally to pay in addition to the total consideration price. It is also seen that 36 days after submission of the written statement, On 3/11/2021, the appellant submitted before the RERA a formal deed of agreement dated 27/12/2018, purportedly signed between him and Srimati Pinky Bansali, wherein the latter agreed to pay rupees 5,44,000 as balance amount within a period of 12 months. It was the case of the appellant therein that the said document could not be placed earlier as that said document was misplaced. On the other hand, the Srimati Pinky Bansali had categorically stated that the said deed, being said deed of agreement dated 27/12/2018, was a false document, and her signature on the deed were forged, for which she had also lodged an FIR with the police in the matter. It is also seen that on the basis of the said FIR which was lodged, an opinion was rendered by the Directorate of Forensic Science, Assam, dated 5/1/2022. Wherein it was opined that the document dated the document, that is the deed of agreement dated 27/12/2018, was not a genuine one. On the basis of the above, the RERA authority passed an order on 18/5/2023 passing various directions to the appellant to allot parking space to Srimati Pinky Bansali. Further directions were also issued to the GMDA as regards the illegal construction so carried out of the 3 flats on the ground floor and the roofs on the rooftop of the 2nd floor. The RERA authority further taking into account the joint inspection report, directed the appellant to ensure that sufficient water was provided to the complainants for regular use. On the question of drainage problem, the RERA authority observed that as per the joint inspection report, there was no proper drainage system in the building and directed the appellant to maintain proper drainage system. On the ground of electricity problem, the RERA authority, on the basis of the report of the joint inspection team, observed that because of the construction of the 3 flats on the ground floor and the room at the rooftop, the total available capacity of 13 kilowatts was not enough, and the appellant was directed to ensure that there was no shortage of load capacity. On the aspect pertaining to the security problem, the RERA authority, on the basis of the deficiency noticed in the joint inspection report, directed the appellant to take necessary security measures. Further to that, as regards the common space, the RERA authority drew attention to clause 20 of the sale deed and directed the appellant to provide common space to the complainants as per the terms and conditions of the sale deed. This court at this point also finds it very relevant to take note of the observations of RERA authority to the effect that the sale deed dated 28/2/2018 categorically mentioned that the transfer was made in respect to the Schedule B property. And the Schedule B property included the flat number 1C, along with 1 car parking space and 2 bike parking space on the ground floor, public the parking space, undivided proportionate share of land, and common amenities and facilities. It is also seen from the sale deed, the contents of which is also reproduced in the order of the appellate authority, that the appellant had duly received the entire sale consideration amount of rupees 15 lakhs and have also mentioned in the deed of sale that nothing remains due upon the said purchase, upon the said purchaser towards the sale price of the aforementioned flat under sale. It is also seen that the appellant raised various preliminary objections as regards the maintainability of the said proceedings initiated before the RERA. On the ground that the area of the plot was less than 500 square meters, and the number of apartments is less than 8, semicolon. The construction was started prior to the date on which the RERA Act came into force, and the RERA had no jurisdiction over a private seller like him who sold some flats due to personal necessity and whose project is not registered with the RERA. To the say, the RERA authority categorically opined that that as per the available records in the project area was 509 square meters. And further, as per section 2Z bracket ZN bracket close of the Act of 2000 of the RERA Act, even if one apartment is sold, the project becomes a real estate project. Being agreed by the order dated 18/5/2023 passed by the RERA authority, the appeal was preferred before the Assam Real Estate Appellate Tribunal, which was registered and numbered as all caps say REAT Assam all cap appeal all cap number 09/2023. The said appeal was dismissed by the Learned Appellate Authority by the impugned judgment and order dated 16/10/2023, and as such the present proceedings. In the backdrop of the above, let this court therefore consider as to whether the questions of law, substantial questions of law so proposed are substantial questions of law that can be formulated in terms with section 100(4) of the code. The first substantial question of law arises, proposed is as to whether the building of the property owner is a promoter if he is not engaged in commercial activities and sold any portion of the property flat out of his hardship. This court finds it relevant to take note of section 2ZK. ZK is one, second, which defines the term promoter. From a perusal of the same provision, a definition, a person would come within the ambit of a promoter if he constructs or causes to be constructed an independent building or a building consisting of apartments, or converts any existing building or a part thereof into apartments for the purpose of selling all or some of the apartments to other persons and includes his assignees. The definition of the promoter also includes such other persons who constructs any building or apartment for sale to the general public. The explanation to section 2ZK also shows that where a person who constructs or converts a building into apartments or develops a plot for sale, and the person who sells apartments or plots are different persons, both of them shall be deemed to be promoters and shall be jointly liable as such for the functions and responsibility specified under this Act. or the rules and the regulations made therein under. Therefore, from the above, it would be seen that the definition of promoter is very large, very wide. And would include, therefore, the appellant in the facts placed before, which is before this court. Considering the above, the said substantial question of law so proposed cannot be a substantial question of law that can be framed. Apart from that, it is also seen that both the RERA authority as well as the first appellate authority have duly taken note of the said aspect of the matter and had come to a fact finding to the effect that the appellant is a promoter. Next. The second substantial question of law is as to whether RERA is a competent authority to decide the complaint if disputed questions of law and facts and pure questions of law is involved. From a perusal of section 34, 35, it will be seen (34 and 35) of the RERA Act as well as Rule 24 of the Assam Real Estate Regulation and Development Rules 2017 have the power to decide various disputed questions of fact, law, and facts. The pure question of law to be decided by the RERA authority in the present facts does not arise. And as such, the said aspect cannot be brought within the ambit of a substantial question of law. Therefore, the second substantial question of law so proposed cannot also be formulated as a substantial question of law within the meaning of section 100, bracket 4 of the code. The third substantial question of law so proposed was as to whether the order of RERA is suffered if it is not passed in its full strength in violation of section 81 of the RERA Act 2016. The said aspect of the matter was duly taken note of by the learned appellate authority. And relying on the judgment of the Supreme Court in the case of MS New Tech Promoters and Developers Private Limited versus State of UP and others reported in 2021 SCC Online SC 1044, and observed that the delegation to hear complaints under Section 31 of the RERA Act is by a single member is permissible. The said being already, the said aspect being already settled by the Supreme Court, the same cannot be the question of law, the substantial question of law so proposed cannot be said to be a substantial question of law involved in the instant appeal, which can be formulated. Apart from that, this court also finds it relevant to take note of that the order passed by the RERA have also not been placed before this court. And apart from that, this leads this court to take the fourth substantial question of law to propose as to whether RERA and RERA, R-E-R-A and R-E-A, can accept opinion of the FSL report if the same is sub judice in a trial court between the same parties in respect of other cases without trial and past order and judgment. This court finds it relevant to take note of section 35 2 of the RERA Act, which empowers the RERA authority the powers of the civil court under the Code of Civil Procedure in respect to various aspects, including any other matter which may be prescribed. The prescription therein could be seen from Rule 24, 1B of the Assam Real Estate bracket Regulation and Development Rule bracket close Rules 2017, which categorically empower the authority to requisitioning subject to the provisions of section 123 and 124 of the Indian Evidence Act 1872, any public record or document or copy of such record or document from any office. Under such circumstances, taking into account the issue involved, in the opinion of this court, the RERA authority as well as the First Appellate Court have rightly taken into account the FSL report. In addition to that, this court also finds it relevant to take note of that the RERA Appellate Authority did not only rely on the FSL report to come to a conclusion that the agreement entered into, the purported agreement dated 27/12/2018 was not a genuine document. But the learned First Appellate Court had also taken note of the registered deed of sale, wherein it was categorically mentioned that after the payment of the 15 lakhs, the property which had been moved specifically described in Schedule B to the deed of sale could be conveyed to Mrs. Pinky Bansali, and therefore the deed of agreement Schedule B could be conveyed, which included the parking space. Under such circumstances, the said substantial question of law proposed is not a substantial question of law involved in the instant appeal. Consequently, this court finds no other substantial question of law being involved in the instant appeal for which the appeal stands dismissed with a cost of
I
rupees.
may be allowed to cite some citation.
Cost of rupees
The relevant one.
10,000. Cost na lahat sa appeal.
Highly obliged.
What also is that one?
Yes, what is this? Both of you want at the same place?
Yes, your lord.
You are?
I am I am petitioners in transfer petition 21.
No, who are you? You are the second wife.
No, I am the driver and owner of the vehicle.
You are the driver and owner of the vehicle. You are where?
We are from Shivsagar district.
Who and which HDFC Argo is not served? Who appears for the HDFC Argo?
DFC.
Without them, it would be difficult, na?
And
Who is appearing? Neither ID card. So service is not complete upon respondent number 2.
Is to respondent number.
Huh?
I'm 23.
That's the petition 116.
What's the step says you got respondent number 2? Oh, okay. You take first steps. Dito likhyo ha. Take etat itu third respondent. 116 sorry, itu third respondent. That it appears that the service upon the respondent number 1 in transfer petition number 116 of 2022 and the respondent number 2 in transfer petition number 21 of 2023 is not complete. Under such circumstances, both the petitioners in both the transfer petitions are directed to take fresh steps upon the said respondent within 3 days by way of registered as well as registered rate. Trustee, not possible. Can we finish up unnecessary? You are losing out. It's in ABC. In addition to that, this court further directs the petitioner to take service by way of trustee upon the state respondent by trustee and file an affidavit of service on or before the next date, rooted to the registry of court and file. List the matter on 1st of May.
Lordship. Interim lordship may be.
Interim order partially.
Oblige, Lord.
May it please, Lordship. In this case,
Oh, a lot of people died. What are you doing?
Lordship.
5, 9, 11, 14, 15.
Lordship, some time may be given to file substitution.
The learned counsel appearing on behalf of the appellant submit that taking into account the office note dated 28/11/2023, the appellant would request some accommodation for taking steps. It's the matter of the COVID. In the meantime, the appellant shall take due steps.
My lord, in the meantime, respondent number 1 also expired.
One on.
Yes.
Take steps. Mr. S. Dutta, the learned senior counsel. Who? You are paying for
We are
respondent
appearing
number
from 1 to 4.
who, Mr. S. Dutta, the learned senior counsel. Put his name.
Shubham Dutt.
The S. Dutta, the learned counsel appearing on behalf of the respondent number 1 to 4 submits that the respondent number 1 expired on
My lord, very recently, maybe 20 days back.
have to give a date now.
Yes,
because
I'll give all the feedback.
have very recently expired and he would provide the details to Mr. So-and-so, the learned counsel appearing on behalf of the appellant. So taking into account the above, list the matter after 6 months.
Lord, I have also filed one IA application 2306 of 2024. It's not on record. My lord, that may come up.
You can't take it up.
Oblige.
The senior counsel nearly. Yes, service not complete.
I have put the respondents number 1 and 3 in this case. Okay?
Huh?
Respondent number 1 and 3.
Respondent number 1 and 2.
1 and 3.
What about the others?
For number 2, I don't know someone else.
IFL question. Where is that?
Respondent number 1 has already expired, my lord.
1 is expired.
1 is expired.
2 and 3 you are appearing.
I am paying for 3.
What about 2?
2, I do not know who.
2, the elder brother, you are not appearing.
No, I have put.
Okay, none appears out there. Na? You will record the respondent number 1 at that. Is there any order against you?
No order, my lord.
No order.
It is 2019 matter, my lord. They have come to challenge the order of injunction of 2019.
But I can't do that. One person has died.
So that may be recorded.
None has appeared on behalf of the appellant today. When the matter is taken up. Mr. H. Sharma appearing on behalf of the respondent number 3 submits that he was earlier representing the respondent number 1 who expired on
28/7/21.
28/7/2020. List the matter up. I'm taking up. I'm not writing. Don't worry. Today I'm here. I'll take your matter.
I have got not open.
Okay, we'll take it up. Where's the other side? We'll take it up. I have 50 to give.
Also, what happened, Your Lordship, it is a matter between brother and sister till the partition. And that partition should Your Lordship will fight. We filed because one of the owners, he was actually enjoying the property, depriving the other owners, that is the sister. So this suit was decreed by the trial court, Your Lordship, that the plaintiffs are entitled to 4/5 of the share of the suit property. 4/5 of the suit property, Your Lordship, and that was the decree, Your Lordship, it was passed. As against that, Your Lordship, the other side, that is the defendant side, Your Lordship, preferred an appeal. First appeal, Your Lordship, in the first appeal, Your Lordship, the judgment and decree passed by the trial court, Your Lordship, it was confirmed after. Considering that this the owners are there and the owners want their separate property, separate share, Your Lordship, and that was upheld by the trial court. Upheld by the trial court, and it was upheld by the appellate court also. As against the judgment and decree, Your Lordship, have come to this Honorable High Court, Your Lordship, by filing this title appeal 9 of 2023.
Ali,
And
see the order which was passed, maybe not with you being present, but that order was passed till returnable date, the execution of the judgment is state.
Lordship,
It became returnable on 6/12/2023. Thereafter, it has not been extended.
extended the law.
No. So, what do you mean?
Sir, we want, Your Lordship, that our caveat, Your Lordship, which was filed, Your Lordship, before the-
Understood. Your basic case is the order should not have been passed without your caveat. Very well. The order was passed without your caveat, rightly or wrongly, whatever may be. As on date, this order is not there. What am I going to do?
So that order, Your Lordship, the law, Your Lordship, is so far our court decision, High Court decision, and the Supreme Court decision, Your Lordship. These are not effective orders, Your Lordship. Those orders have the court. And on that basis, Your
I can make it very clear that pursuant to 18/1/2023, the order was not extended. So under such circumstances, nothing remains. And I'll dispose of your application. I think that is very in a easy method.
that is here, Your Lordship. Appeal was admitted, Your Lordship.
So what? You
Without
want, you
hearing,
you can have a say as regards the appeal, admission of the appeal.
Lordship. Anyway, we can point out, assist the court, Your Lordship.
You
that there is
can't.
no substitution.
No, no. You have no business out there.
For her, that is, anyway, Your Lordship,
Mr. Ali, you are a seasoned civil litigation lawyer.
Whatever
Tell
order
me,
is
under what provision you issue notice in an appeal without framing a substantial question of law?
Lordship,
Can you do that? Is it proposed? Is it conceived? No. You will be only asked after framing of the substantial question of law under 104 as to whether those questions of law so framed are involved in the appeal.
Lordship, that is there, but because so many cases we have seen, Your Lordship. At
I
the
don't do
time
that.
of admission itself.
You want me to change it? Then I'll keep on issuing notice which will have a far-reaching consequence.
Then, Your Lordship, at least the order which has been passed, is saying. is
Yes, Mr.
suspended.
Vishwas, that order
Your
was not
Lordship,
extended.
That does not an order.
The
has
order
been-
dated
Your Lordship.
18/1/2023 was not extended after it was only till the returnable date. Returnable date was 6/12/2023. It was not extended thereafter.
Immediately after they filed an interlocutory application challenging they filed an IA civil, challenging the order of stay on the ground that they were not intimated because they filed a caveat and the registry.
Understood, but that order is no longer extended.
So the coordinate bench of this honorable court was taking up that matter.
Which matter?
That IA.
I is okay, but I will close it, saying that that order was not extended, nothing remains in the I. Again. Look. This is an application filed by the respondents as applicant, seeking recalling of the order dated 18/1/2023 passed in IA civil number 122/2023. Inasmuch as the said order was passed bypassing a caveat dated 22/11/2022. Taking into account, now this court have duly perused the order dated 18/1/2023 passed in IA civil 122/2023. It is also seen that the said application being IA civil 122/2023 was filed on 21/12/2022. Was filed on 9/1/2023. 9/1/2023. Under such circumstances, when there was a caveat lodged, the registry ought to have pointed out the said aspect of the matter. Be that as it may, this court have also perused the order dated 18/1/2023, wherein it has been mentioned that till the returnable date, the execution of the impugned judgment and decree dated 9/11/2022 passed in title appeal number 05/2020 by the Court of the Learned Additional District Judge, number 3, Kamrup Metro at Guwahati, shall remain stayed. Thereupon, the matter came up on 6/12/2023, as could be seen from the records of the regular second appeal, as well as the instant application. The said order dated 18/1/2023 thereupon was not extended, meaning thereby there is no further stay in respect to the judgment and decree dated 9/12/11/2022 passed in title appeal number 5/2020. Under such circumstances, the instant application have become infructuous, for which the same stands closed. Now this is then IA cannot IA civil 122/2022, write it. Mr. S. Biswas, the learned counsel appearing on behalf of the applicant, submits that you want to argue?
My lord, the RSA was admitted on a substantial question of law.
Those substantial, I'll dismiss it right now. Don't say on those substantial. Those are not substantial question of law at all.
But right.
Can you have a substantial question whether the judgment and decree is perverse? Right? Substantial question of law has to be that, look here, on these facts being not considered, whether the judgment, the learned trial court judgment is perverse. You have to see that. Not say that it is a perverse.
But the records have to be seen, the evidence, and the section 6 of the Hindu Marriage Act.
It has not been framed.
After it is framed, my lord, I have given by memo of appeal.
And
Mr. Biswas,
I raised
whether
that,
the findings arrived at by both the courts below is perverse.
but when I pleaded this, my lord, the learned coordinate man said me, my lord, that this will be enough. My lord, I cannot go beyond what the court says, my lord.
Hello, what do you want to do with this?
My lord, this stay may be extended, it may be taken up for final hearing.
I'm
my
not
lord.
going to
My lord, it's a
extend it.
matter, my lord, partition. The widow lady is
No,
residing
when
in
this order has been picked, yeah, this matter is pending. So we can have this IA picked on some other date for hearing. Not today.
well, unless your lordship extend the IA, well, the execution would be more
How
than
can I extend something which is not there? I can extend something which is there.
well, after that, when the matter was taken up on 6/12, my lord, the learned
Court did not extend it.
yes, my lord, but because that was not under the consideration, the court was looking at the interlocutory application filed on a ground that, my lord, the
I
caveat.
dispose it of.
Well, I filed an objection there saying, my lord, since there was no caveat and since there was no information from the registry, I as a counsel cannot go and search out whether there is a caveat or not. It is the
So in the order,
either party.
so in the order, I have not blamed you. I blame the
No, I
registry.
am just submitting for my satisfaction, my lord.
Now, what do you want? You don't want to
My
press
lord,
this
my
application?
regular second will become.
No, do you want to press this application or not?
Yes, my lord.
We'll have it some other day. Yes, when?
Lordship, in that case, your lordship, next date, your lordship. Next week.
Mr. SB Plus orally submits it to I 122/2020. Orally submit that the said application, that the stay sought for in the said application be extended to Mr. S. Ali, the learned counsel, opposes to the same. The said aspect would be taken up for consideration on 3rd of April.
But till that, my lord, no coercive action may be taken. My lord, I am a widow lady residing alone, my lord. The daughters are claiming over the parental property, my lord. It's only 10 acres of land. They are claiming entire 8 acres, my lord. I stay there with my younger son, my lord. And
Has
they,
the execution been filed?
yes, my lord.
When is the next date?
So next date, my lord, I am not aware, my lord. I have not received a notice. My lord, perhaps
You don't know. We'll have it on third. Third, no? I fixed
my
it.
lord, one line, my lord, will be sufficient. It will save my life, my lord. I am a widow lady, my lord. After my husband expired, I am residing here.
Whatever order has been passed, your lordship.
I'm not going to
What
do
is
that. Next.
apex court, your lordship, these are
I'm
all.
fixing it on third.
Right?
Third or second next better. What is this?
Office note dated to 1/2/24, my lord, services complete. my lord. Upon the respondent, all the respondents.
I am appearing for lordship 1/3A to 3E and 4.
What to do about 5AB?
It is complete. Service
complete.
completed.
Service is complete.
There is office note, my lord.
It is all done by hanging.
Hanging. Everything.
My lord.
No, but has the authority, Lordship Court decided on that?
Yes, yes.
Yes, my lord. Order 1/2/24.
It has been done.
Yes, my lord.
Okay. Taking into account the service is complete. LCA received.
LCA notice.
Not received, my lord.
Received. List the matter for hearing. Full stop. No, LCA has been
LCA
received. LCA has been received.
My lord.
Taking into account that the service is complete and the LCA has been received, list the matter for hearing in its usual course.
What is the interim?
What interim?
What is the
Okay, interim is there in the main case. There is the IA.
Stay, my lord.
Huh?
Yes, my lord. There is a stay.
IA what? IA stay. There is no IA business.
No,
out there.
Order dated your lordship to 4/3/2020, my lord. Then, when the 4/3/2020, my lord. Order dated, my lord. There is stay of the execution of the process.
There is no IA here. IA will be somewhere else. IA thing is there. Huh? There is no list. I can't extend it in the appeal.
Please, your lordship, we have withdrawn our wakalatnama. Additional affidavit has been filed. Registry may be directed to strike out our name.
Okay. How much delay?
1,000.
Track of the names of defendant number so and so await service report. You have filed an affidavit.
Yes.
Delay in filing is condoned. Register the main case. Right? None appears for the applicant. What IA? IA for what?
IA for condemnation of delay.
Huh? Delay has been condoned.
Sir, that item-
What?
What the item number in 1536?
1536. Itu agak tu ki hoy. It was some dismissed. You are the sole respondent. You take fresh steps.
But if they have withdrawn the Upalatama, that is also communicated to the respondent. They have also, they have filed the affidavit, additional affidavit.
They have sent it by postal receipt. So you file and take fresh step.
But if may I submit one,
Each step. Submit.
that already the respondent have been informed that about the case, about the matter, and he has filed the color. So he has the knowledge about the matter. And they have also withdrawn the account.
We can go ex parte against the respondent. And
But
when the
if-
delay is so much,
If after having invitation, if someone is not interested to attend the court, then I will send the certified comply. Then again, he will not appear. It is up to the court. Lordship may,
have they received that notice?
yes, they
The
have
notice
filed the
which you have
postal,
sent, have they received it?
postal acknowledgement slip is there. They have filed just I just had the case received.
Information regarding with regard to have they received this? Received?
Yes, Lordship, the postal track report is there. It filed, they have filed along with their additional affidavit.
This court duly takes note of an affidavit, additional affidavit filed by the counsel of the respondent stating inter alia that he had already intimated the respondent about withdrawal of his engagement in the appeal. So this court have also taken note of annexure A, B, and C, which shows that the withdrawal of the information were duly intimated to the respondent. So under such circumstances, this court fixes the matter on 5th of April 2024 on 6th of May 2024. The registry is directed to intimate the instant order by way of usual process to the respondent in her address.
Obliged.
Yes, what are these?
May it please your lordship. Lordship, kindly see the order dated 5/6/2023. Lordship, I am the cross objector and our cross objection was admitted, Lordship. So let it be fixed for admission here, Lordship.
What do you say? Cross objection has not been admitted.
Admitted, Lordship.
Then it will be fixed for hearing.
Yes.
LCR received. So, taking into account that the LCR has been received and the parties are duly represented, matter stands the registry shall list the matter for hearing is usual for.
May I pay for
Alan, I
Yes,
Yes.
Lord.
service not complete.
Dr. Service complete Malania, advocate one A for him APR matter. As per order.
Unserved, not known, solicited, sole respondent expired.
As per order matter.
Huh?
As per order.
List after 2 weeks, list after, Are Mr. So-and-so take here for the opposite.
AR for him APR matter.
Ah, but there is only one respondent.
No, my lord. The whole respondent expired. Thereafter, we have filed, my lord,
Substitution.
substitution already
Then who appeared?
AR for him.
His name is shown in the list.
No, my lord. Today is not one. That's why.
So the registry has not shown the name of Mr. A.A.R. Karim Kustam. Under such circumstances, the registry shall list the matter after 2 weeks showing the name of Mr. A.A.R. Karim appearing on behalf of the respondent. 51.
Second appeal, my lord, some delays were there, my lord.
What is this?
Thereafter, my lord, we filed substitution.
What is this IS for?
IS for my lord, substitution of legal here, setting aside abatement, etc.
And
And my lord,
delay of condemnation?
how much?
Yes, 539 days.
Why?
Because my lord, in the meantime, my lord, yes, stated, my lord.
My lord, what happened? They filed the RSS prior to RSA. The respondent was died prior to filing of this RSA. So they filed RSA along with the continuation petition after 4 years. Thereafter, after 2 years, they filed this instant IA,
That
the
information.
abatement of the case. And that came, their ground is that information came from me, my lord. But in their IA 378819, in that IA, they stated that they have knowledge from 18A to 2000.
Mr. Counsel, all these things will not come into play. You can't file Order 22 Rule 4, Order 22 Rule 9, Order 1 Rule 10, Section 5. All these things are not applicable because Order 22 Rule 4 does not come into play. So what do you need to do? Think about. Okay, these applications are useless.
And this matter has become abated, my lord. The respondent has died.
Only sole respondent.
Sole respondent.
Wife
Both the
and
respondent.
Huh?
Wife and husband.
Wife and husband.
Both are dead.
died
Yes. both.
during the pendency of the
You
execution
can't help.
case.
Land has also, my lord, already, my lord.
The decree was already taken place. We have got the position below.
Nothing. Everybody died.
Everybody died.
Wife and husband both.
They just
And all died, both of them died before the appeal.
before prior to filing this petition during the pendency of the execution case.
Did not participate there, my lord.
When did they die?
Yes, my lord.
We dismissed the entire thing. Necessary.
My lord, husband died, my lord, 14/6/2018.
Who?
My lord,
Respondent number one.
Logendra Homi.
14/6.
14/6/18.
And the other one?
Other one, my lord,
21.
5/2/19.
Huh?
5/2/19.
19. And when did you file the appeal?
Appeal was filed, my lord,
16 appeal was 19/8/19. 19/8/19.
19/8/19.
Sorry, not 19. I don't
Uh,
have the.
And when was the decree passed?
August 19, my lord.
Huh?
August 19.
August 19, 19/8. And when was the decree passed?
16/6/17.
Delay also is there. The instant appeal under section 100 has been filed against the judgment and decree dated 6/6/2017,
17.
passed by the learned court of the civil judge Nagaon in title appeal number 16/2016. Thereupon, admittedly, thereupon, on 14/6/2018, the appellant number 1 in the appeal expired, and the appellant number 2 expired on 5/2/2019. And the appeal was filed on 19/8/2019. Hey, Ronga no এতিয়া round top কিতাপত লেখো ইয়াৰ.
My lord,
One of-
did not inform me.
All dead people you have filed. How can dead people file?
Did not inform me. He did not participate in the my lord, execution process.
How did he file?
Execution procedure, execution is filed by us, Your Honor. Why I have to participate
No,
in
no,
the
no, no.
execution?
How did you file? These
Did not
people were
inform me,
long dead. You file an appeal. I would have understood.
Yes.
You were filing some other thing. You are a respondent. Something may happen. But the other appellant is dead. Appellants, na?
They responded.
Both the appellants. No, no, sorry, respondents.
They are respondents.
They are appellant.
They are appellants, we are respondent.
That is what.
Yeah.
How could he file people of dead?
Even knowing
No, no,
the
no, my
same.
lord.
Your
They are
Honor.
the respondent here in the second appeal. We serve notice to them. Thereafter, office notice.
First of all, Mr. Das, how could you file an appeal of dead people? Who came to you? My goodness. Therefore, on the face of it, it appears that this appeal has been filed by dead persons.
Against the dead person.
Against the dead person.
Who is dead?
Respondent number 1 and sole respondent.
Oh, you are appearing for those people.
Those people,
Okay, not them.
not them.
Appellants are alive.
Appellants are alive.
Okay, appellants. Okay. Therefore, it appears that the instant appeal has been filed against dead persons. Consequently, the provisions of Order 22, Rule 4 would not apply when neither the suit or an appeal is pending. Accordingly, the instant appeal which have been filed against the dead person is totally not, is misconceived. It is not maintainable, for which the appeal as well as all the applications so filed stands dismissed. I এখনো লিখে দিব appeal as well as all applications filed. এখন কোবা এখনো লিখে and
3780.
March of it.
public. Yes. My goodness.
May I please your lord, my lord. Now, in terms of the order.
Yes, Mr. Pulkayastha, that day, Mr. Pulkayastha,
Hello.
that day in that matter, huh?
My lord.
What matter? Prabha Malati or something. That judgment, na, you have order 22, rule 4.3.
Yes.
I had taken the, because you don't get such matters.
My lord.
Okay. I had taken the liberty of writing a few more lines to the judgment on the basis of what is your right to sue and all. Yes. Although the faith of your petition still remains dismissed.
It has a.
But you don't get an opportunity to write. Now that these type of matters, you don't get an opportunity. But yes, tell me.
My lord, as per the office note, it is 7/6/2023.
Hmm.
My lord, service report in respect of as per number 2, 3, 1, 3, 2, and 3.
R2 is expired.
My lord, R2 expert. So I need, my lord, possibly to take some step for substitution.
Mr. A.K. Pulkayastha, learned counsel appearing on behalf of the appellant, applicant,
Yes. My lord,
seeks for an adjournment. I would not say more than that.
my lord.
If I say more than that, I have to say it has a bit.
My lord, lordship can give me 4 weeks time.
I'm not saying anything.
Then tomorrow matter may come, my lord. I'll be in big trouble.
Which one?
Item number, my lord, 22.
No, these.
One
These
of the-
item 23, 22.
22. That's
Seeks
one
for an
number 4 back.
accommodation. List the matter after 4 weeks.
Because
I won't
I
say
will have
more
to
than
take
that.
steps.
As if I have not seen what has happened. Yes. What is this?
So it's a RFA.
May I please your lordship?
Ah.
Lordship, I am not in the case. G. Khandelia, Advocate G. Khandelia is in the case. So I am representing G. Khandelia today, lordship. I
Okay.
don't have Vakalatnama in the case. G. Khandelia is out of station.
How much amount? 29 lakhs, 27,000.
Well, the equitable amount is 39 lakh.
Huh?
39.
39? 29?
But they have already filed an execution petition. But day before yesterday, we got the copy.
Where it is adjusted by a decree of the court of
They
execution.
have filed the execution case for payment for an amount of 1 crore
Ah,
with interest.
very well. What is the
Lordship,
decree
decree
part?
is for 39 lakhs 38,205. The amount is composed of 3 figures. One is 29 lakhs 27,000. That figure they have already admitted in the trial, lordship. And the other 2 amounts are one 6 lakhs rupees for work not measured yet, and one for the SD money that is around 4 lakhs 11,000. 3 figures are there. The total amount comes to 39
SD
lakhs
money,
38,000.
6 lakhs is only against the work done but not
Not
measured.
measured, lordship.
This is
And
6 lakhs
6
and
lakhs is
4
the
lakh
additional amount
only
they have-
against security deposit.
yes, they have
Yes.
forfeited the SD, lordship.
We will stay it subject to deposit of this 33 lakhs,
20, yes.
2 months.
For the Lordship kindly consider, bro. Look, the amount deposited while pending stay, bro. The time basing this, bro. Lordship kindly consider it is the discretion of the court, of course, bro. 2019 ATSCC 112. There, paragraph 21 and 22, bro, for a moment and life.
This PAM developments,
Pen.
you are referring to order 27 rule 8.
And that has been considered and along with that for para 21 and 22.
What does it say?
Ultimately, it's a discretion of the court. But here, what I find a lot in the WS also, they said that 23 lakhs rupees is the due to be paid to them.
No. First and foremost, kindly appreciate.
6 lakhs.
You have admitted 29 lakhs 27,000 in the suit. You said
Lordship,
No, we have.
kindly refer the
In our-
completion certificate. Completion certificate they have issued.
no.
It is
In the
on
trial
page
have they
46 and
admitted?
47.
Mr. Counsel, don't make all this up.
Lordship, kindly come to page 110, 110.
That being the way defendant can't absolve themselves as likely to be appealed. Who has admitted this?
For the 110, kindly come to page 110.
Of
Of the, this is a part of the written statement of the appealment. The first sentence, it starts with the previous statement. The necessary steps have already been taken by the defendant number 4 at appropriate level for the payment of balance outstanding amount of 23,24,693. So this is the amount that I find that
now, have you paid that?
I have taken the instruction that because of pendency of this case,
These 23 lakhs have not been paid.
Yeah.
Now the remaining is 4 lakhs, another thing from that security deposit.
6 lakhs rupees, they
No,
have,
no, no. That 23 lakhs is there plus another 4 lakh 11,205.
so that has been forfeited. We said that the contract has been terminated and that amount has been forfeited. The termination is an issue. The termination is under challenge in the suit.
Huh?
The termination of contract was
Where is your statement about that in your written statement?
kindly para page 104. Page 107 policy. Having no way at
No, the FDs are still lying with you.
but that has been forfeited. I have to get the what they have.
No, Mr.
Those are
you see,
security deposits.
one thing, let me tell you, Mr. Nath. At the end of the day, if this principal is not paid, it gets on going on and going on and going on. There cannot be an interest on interest, remember. That is why they are asking for 1 crore 7 lakh. At least pay the principal so that stops some. 23 lakhs, first of all, if you see order 41 rule 1(3), categorically mentions that in respect to those portion of the appeal where you have duly admitted the question of the appeal being taken or stay does not arise at all. See that? Order 41 rule 1(3). Order 41 rule 1(3) or 3. Huh?
Such.
Isn't it?
41 rule 1.
1(3). Where an appeal is against the decree for payment of money, the appellant shall, within such time as the appellant court may direct, deposit the amount disputed in the appeal or furnish such security in respect of thereof as the court of appeal. So therefore, this disputed, this court can direct. But the only thing is, when you are duly admitting, the appeal does not arise. I only. Now, the amount you have duly admitted this 23 lakhs in your written statement. So pay that. And also this 4 lakhs or whatever, 6 lakhs, whatever maybe.
4 lakhs full of security deposit has been forfeited. Kindly see the page 1.
Okay, you pay the 23 lakhs. Stay subject to this. And 50% of the other amount. 6 lakhs plus.
Full of 6 lakhs we are not admitting. They said that they have executed. We are
6
disputing.
plus 4, 11 lakhs, 11 lakhs, 11 lakhs. Out of that, 50% you pay. And that the remaining 23 lakhs, 24,693. 50% I am only saying that because this will also take care of your interest. So you pay this, I'm staying it subject to you depositing within 2 months, 1 month. Which department?
PW.
Oh, PWD, 10 days.
So, Lordship may give me 2 months time. Because
5 days?
Moral code of conduct is there.
Huh?
For sanctioning the amount, sometime.
No, we are after budget. Budget is over. So you have a lot of money.
No, now is it the end of March? We have difficulty. Kindly give us-
Chalo. Appeal has been admitted.
No. Along with
Admit
the
the
state
bill.
petition, it is
Call for the record. Mr. Soense appears on behalf of the respondent. List the matter for hearing immediately upon receipt of the LCR. This is an application for stay of the judgment and decree dated
For 2-3,
2/3/2023 passed in money suit number 135/2017 by the Court of the Civil Judge number 2, Kamrup Metro at Guwahati. Full stop. This court have duly taken note of the written statement filed by the appellant who were the defendants in the suit, wherein it has been duly mentioned that the plaintiff was entitled to an amount of rupees 23,24,693. Further to that, it is also seen from the decree so passed that the learned trial court held that the plaintiff would be entitled to an amount of rupees 29,27,000 against the executed and measured work, rupees 6 lakh against the work but not measured, and rupees 4,11,205 against the security deposit. It has also been decreed that the plaintiff would be entitled to 8% interest on the amount receivable from 12/7/2010 till the date of realization. Mr. Dina, the learned counsel appearing on behalf of the appellant, submits that an execution proceedings have been initiated being money execution case number 17/2023, claiming an amount of rupees 1,07,16,895.49. Full stop. He therefore pressed that the execution proceedings be stayed pending disposal of the appeal. Mr. Nath, you pay this, not others. Pay this amount. After hearing both the parties, this court is of the opinion that as the appeal has been admitted, the applicant oblique the appellant is entitled to some protection, taking into account the huge amount of money which the appellant would have to pay if the money execution case number 17/2023 is permitted to proceed pending disposal of the appeal. Accordingly, this court directs the applicant oblique appellant to deposit the principal amount as stated in the decree of rupees 29,27,000 plus rupees 6 lakhs plus rupees 4,11,205, totaling to rupees so and so on or before date 20. May 2025. 24. It is made clear that if the said amount is not deposited on or before the said date, and the said amount be deposited before the registry of this court on or before 25/2024. It is made clear if the said amount is not deposited, the said execution proceedings can proceed. So apart from that, this court grants the liberty to the appellant to file appropriate application before the before the registry of this court upon deposit of the said amount to release of the said amount. The registry may permit such release of the amount subject to furnishing of an indemnity bond and after due verification. At the end of the day, you may say, I have done some good thing for the PWD, asking you to pay the principal.
May I please, your lordship, office note?
Yes, Mr. Tom. What is this?
Office
Service
note
not
dated,
complete?
30/11/23. Notice served upon respondent 2, 3 and 4 here.
The service complete?
Yes, your lord.
Service being complete leaves the matter for admission on, there's a stay order
No,
on, what is the matter?
it pertains to examination of affidavit.
And truth has proceeded.
Lordship, one affidavit has been filed in 6 and 4 petition plaintiffs were there.
Hello. List the matter for admission on 22nd of April.
Lord.
It's here, try luck to finish it up.
Okay.
25 here. Or 25 mentioned somebody. Come to file. They have taken your permission. In the morning, that person duly said that, whoever it is, he said that I am appearing, you give me 3 weeks time for filing. I have informed the other side. I remember. They have lodge a complaint before the bar council against the lawyer, whoever. Yes, what is this? Mr. Soam, it's your matter.
Lord.
26.
26, lordship, it ought to have filed,
Why LCR has been called for?
Against the injunction order.
ought to have filed an appeal, your lordship, but only filed application under Article 226.
Appeal lies.
Appeal lies.
So you do so.
Yes,
Sir,
your lordship. I may be
A.R.
allowed to-
Soam, the learned counsel appearing on behalf of the appellant, petitioner submits that an appeal lie against the order impugned in the instant proceedings, whereby the injunction application for file was rejected,
so filed by the respondent allowed.
whereby the injunction was granted. Taking into account that an appeal lies under the provisions of Order 43, Rule 1R, read with Section 104 of the Code. This court dismisses the instant application. However, grants the liberty to the petitioner to, if so advised, to file an appeal as per the provisions of law, and the period from 15/3/2023 till date be excluded, while computing the period of limitation for filing an appeal. The order dated 24/3/2023, whereby the LCR was called for,
LCR has come.
has come.
That may be returned.
The LCR which have been called for by the order dated 24/2/2000 be returned forthwith by the registry. Don't require an LCR for an FAO.
Only your lord.
Yes, what is this, Mr. Mehdi?
We filed a money appeal, my lord, and there is a delay, my lord. And
How much?
that money appeal was delayed, it was rejected by the district. They thought
No, how much delay here?
here no delay, my lord.
What is this IA for?
IA for my lord,
Stay.
stay, my lord.
Is this what matter is this?
My lord, this,
Why the RSA stuff?
my lord, this, RSA, my lord, is because of the, my lord, the yellow statement on page, my lord, 10, 11 from the 11, my lord, is, consideration delay petition was rejected at the appeal, my lord,
Okay.
dismissed.
We have it. List the appeal at the stage of order 41, rule 11, when?
My lord, it is the execution page, pending around 27 days. So, my lord, this matter, on 22nd or 20th.
What?
22nd of
Absolutely no. We'll have it on 3rd of April. On 3rd of April.
Appellate.
In the column of order 41, rule 11. Take the time. Yes, what is this, Mr.
My lord.
Mishra? What are you challenging?
My lord, the petitioner as a plaintiff filed a suit
Hmm.
along with the injunction petition.
Why the matters come today
My lord, for the first time it has been listed after their appearance.
with regard to, you are appearing? All,
My lord, for respondent number 1 and 3,
what about two? Neither ID card or with regard to the service of the, I have been received and notice about what by the sister in. Very well.
my lord, we have not received the copy of the impugned order.
What?
We have not received the copy of the impugned order.
Impugn, you have not given him the petition.
Impugned order dated.
My lord, I have furnished otherwise notice will not go. I find everything.
And this type of argument normally
My
we
lord,
find.
furnished.
Eh? Yeah, give her a copy. Okay, let us have it for admission. List the matter for admission on 3rd of April 2024,
Appellate.
taking into account that the service is complete. Service not complete. List the matter after completion of service upon the respondent number 2 and 3.
interim order may be done. Interim order may be done.
Why? No. No. What is this CRPIO business?
Your Lordship, against the refusal of injunction by the appellate.
Huh?
Regarding refusal of injunction by the appellate court. Your Lord.
Refusal of injunction by the appellate court. Trial court gave you.
No, yeah.
And now you what you have got? Got a long order here. Is against the notice?
Your Lordship.
Then when is the next date fixed?
Next date of the appeal, Your Lordship.
In the trial court? You must have only issued a notice
Your Lordship.
against the filing of a suit.
Yes.
You asked for ex parte.
Yes.
Now the next date is what? Then you filed an appeal against that.
Yes.
The appeal got dismissed.
Not dismissed, Your Lordship. My injunction was not granted. Appeal admitted.
Admitted, but the injunction was
No,
not
yes.
granted. Against you filed an order 41 the 39 rule 1 and 2. Against that you are here.
Yes.
So now the trial court, what has happened to that matter?
That put Your Lordship, the notice dispute, we have taken a step, Your Lordship.
Then we direct the trial court to
Your Lordship.
dispose of the said appeal with the injunction application within
Your
30 days.
Your Lordship.
No, wait. Injunction application within 30 days and the interim order passed here shall continue till then.
Your Lordship.
Yes. Why should these matters be pending here unnecessarily? The trial court is session of the matter. There are not 1, 2. This is the 3rd proceedings which is going on, isn't it? Where is the interim? It made clear that this order would come into effect till the next returnable date, restraining the opposite parties from proceeding with further construction of a proposed building wall or otherwise changing the nature of the yard. Who is appealing for respondent number 2 and 3?
Actually, your respondent number 223 notice issued your lordship. They didn't appear.
Necessary pending 3 matters here. 2 and 3.
Neither the your
You are, who is in possession?
now he is in position.
You are in possession.
I am in possession of different drug and different position.
My allegation that he disposes me.
Eh?
The respondent number 1 disposes me.
Hello, let us have it on next 27. List the matter on 27 at the admission stage.
Your lordship 29.
29, you are going to come.
Because I'll be out for body.
This is the order. Ask your junior. I will pass an order. Let that proceed out there. Only the interim will consider 30 days.
Your lordship.
That's all.
My your lordship.
Service complete.
Service complete.
Okay. Then what to do?
If the matter for, if they want to file an affidavit.
You want to file affidavit?
Yes, my lord.
Okay. 3 weeks time is granted to file affidavit to the respondents who are to the councils representing the to the respondent numbers 1 and 2. List the matter after on
Lord, I am
15th
appearing
of May.
for respondent number 3, 4, 5, 6, and 7. 3 to 7.
you.
I'm 1 to 2. 1 and 2.
Time is granted to the respondents who are duly represented to file their reply. List the matter on 8th of May 2024. In the meantime, the replies, affidavit in oppositions, if any, be filed.
Obliged.
Yes, what is this?
Look, I have filed an application for permitting me to put in 6, whatever structure I have already met. And without item 49, they have filed an application for violation of structure order.
Other side is not there, na?
Without
Wait, let us adjourn this matter for today. 31 and 49, editor. Both are connected, na? 39 and 41 or AK matter. Be taken up, be listed again on 26th of April. Okay. Mr. Sahu, that cost 75, I'll make it 50. Okay. $32.
Please, your lordship, the in order, it is paid 30 lordship. Due to some submission actually incorrect made by the landed council, your lordship.
Oh, yes.
So it was disposed of.
What do you have to say?
I'd like to file an affidavit, Your Honor, because I have deposited.
Yes, Mr. Bhattaji, what do you have to say?
I
You have
am
nothing
for
to-
respondent 1 and 2.
You have nothing to
So we are not entering it at this stage, my lord.
You
We have to
entered,
get
you
to
are
the
already,
facts first.
you are already there, standing out there, so you are already entered. Now here, why did you make a false statement before the court? And because of that, this court disposed of the matter.
Actually, I have deposited some installment before the Batija.
No, what you have stated out here is this is the only amount remained. It submits the balance now payable to the petitioner is rupees 45,000, which shall be released to petitioner on a month. Taking into account the undertaking, this court disposed of their director here to ensure that the amount is be released on so and so. Now they find out that it's much more.
Yes, it 8 lakhs 50,000 about the certificate, and they have deposited as admittedly less than 6 lakhs.
You do one thing, file your reply. I fixed it on, I have issued notice, na?
Yes, sir. They have appeared after.
I have issued notice. Look, Mr. Soento,
GC Bora.
appearing on behalf of the STC. That is the respondent number 3. Take for an accommodation of filing a reply. To list the matter on 24th of April 2024.
I'm appearing for
A
respondents
reply
one
be
and two.
filed on or before the next day.
13
Yes, Mr. Bhattacharya, give your name. All your names out there, they put it out. Yes. What is this?
My lord, I file the internal application, my lord.
Huh?
I filed a petition for stay of the judgment decree. Appeal has been admitted, but on that day we could not file the petition for stay of the judgment decree. Now I file a judgment in the meantime, they file a execution proceeding. So I filed this petition IA number 399. Still pending of this appeal. The impung.
And what is the other?
After this, my lord, I file for stay of the execution proceeding.
What?
Execution proceeding.
One stay. And the other is for stay.
Other is not required.
Execution is state, my lord.
Other is not required. One is accepted.
In fact, my lord, the court below has already granted some stay.
But they
Unaccepted.
court will guarantee the stay, but they asked me to produce the stay order. Court will ask me to produce the stay order.
When is the next date fixed?
My lord,
When is the next date fixed?
next date fixed. It was fixed on 13/12/2020. Thereafter, the court is not.
Huh? 13?
13/12/2023. It was fixed, but thereafter I am not calculated.
Hello, we will wait for this. You file it on 2024, 2 days before, and you don't know what is the next date fixed. Can't help it, mister.
But they informed me that
Take your time. Have you filed are you filing reply?
My lord, I am to file.
Okay. Mr. A.R. Sikdar appearing on behalf of the respondent submits that he would like to file a reply to both the applications.
Your Lordship, I'm appearing for the respondent number.
Appearing on behalf of the counsel representing the respondent submits that they would like to file replies to the instant applications, both the applications. List the matter on 24/4/2024. In the meantime, the replies be filed.
My lord, till then, my lord,
No till then business, you don't know. No till then. You have to know when you are filing, you file the appeal in 2023. It gets admitted. And now you in 2024 you file, you don't know what is the stage.
no, 13/12/2023 it was fixed. But what that no order.
Very good.
Because my presiding officer.
Don't worry, nothing is going to happen. No court does anything.
Available.
Yes. Yes. What is this?
This is also for stay of the execution proceeding, my lord. My lord, on the other day, my lord, this honorable court directed us to take instruction, my lord, as to the amount, my lord, that we can deposit or grant of pay.
What is this FAO business?
FAO, my lord, because my lord, there was a suit, my lord, money suit against me, and it was, my lord, decreed ex parte. No summons was issued against me.
Then you filed an order 9 rule 17,
My lord.
13.
Yes.
Then
Then it was rejected.
Then-
after we file appeal. But,
where? Here.
my lord, before the learned court below.
Huh.
But since disciplinary jurisdiction is not, my lord, up to 10 lakh before district judge. So the court said, my lord, file it appropriate. And accordingly, we have filed this FAO.
When did you file this FAO?
My lord, it was filed on 2020.
Then?
It's
an order 7 rule 13 application. Your order 7 rule 13 application was rejected.
Ordered,
Or order 9 rule 13
yes.
was rejected.
That was,
And against that rejected, who filed the suit?
my lord, they filed the suit.
Boroland Territorial Council.
My lord.
You filed a suit.
Look, it was filed not by the secretary to the government of Assam, but filed your lordship knows, my lord, section 79. of the PPC was filed by PPC council, secretary PPC council.
Hmm.
For that.
So it can be done as per the act, no?
But
It is
he
connected
has
to
no jurisdiction, Lord. And we have taken this plea in the appeal, Lord. All this.
That is not the subject matter here.
That is not now, my lord.
That is not the
Now-
subject matter.
Now, my lord, it is.
Hello,
that-
we'll have it on summary. Hey, bhai, kite Arjun Kori. Yes, other matters then.
Lord, as you have taken instruction,
Huh?
Lord, as you have instructed, my lord, 2 lakh rupees you can deposit, my lord, if your lord, because my lord, breach of possession for attachment of my property has been.
Mr. You have urgency? You have urgency on? Tell me.
Some urgency is there.
The
my lord.
manner in
That's
which
why
you are saying, it seems that you don't have urgency.
my lord, there is urgency, sir. The lordship knows
If there is an urgency, then tell me you have an urgency. I'll hear it on some other day. If you don't have, forget it. There are too many matters. We'll have it on some other day. We'll have it on a matter to Lisco 8th of April.
All right.